Good morning, everyone. Please be seated. May I request Honorable Mr. Justice Dinesh Maheshwari to come on the dais, please. May I also request the Attorney General for India, Mr. R. Venkataraman, to please come on the dais, please. May I request Mr. Amarjeet Singh Chandiok, President-elect Bar Association of India, to be on the dais, please. May I also request Mr. Shyam Devan, President-elect Law Asia, to be on the dais, please. Can I request Ms. Rachna Srivastav to give a bouquet to welcome our chief guest, Honorable Mr. Justice Dinesh Maheshwari, please. The bouquet? 2 minutes, I think they're just bringing it. Rachna ji. May I request now Ms. Anandita Pujari to give a bouquet to our Attorney General. Thank you. With the permission, can we commence the proceedings? I'm obliged. So, I request Mr. Amarjeet Singh Chandiok to please come on the dais and make his welcome address.
Honorable Mr. Justice Dinesh Maheshwari, Judge, Supreme Court of India. My dear, the learned Attorney General for India, Mr. Venkataraman. BarAssociation of India, Mr. Prashant. Mr. Shyam Devan, President-elect, Law Asia. I have dignitaries from India and abroad, Advocate Generals, other dignitaries. Welcome you all to Bar Association of India's New Delhi International Rule of Law Convention. We at Bar Association of India, I'm proud to say, start from Ladakh and go right up to Kanyakumari. Our executive committee has members from all over the country. We already have associations with many other parts of the world. The dignitaries from outside speak for itself, that they've come all the way to be with us. There are participants from many parts of the country. We welcome you all. The convention will take us to the new views that we need to discuss. It will take us to what today business requires to look at. It will also look at why should not we be human first, in whichever capacity we are. We'll look at what are the dispute resolutions that we have today. I'm sure these sessions would help us debate on it, discuss, and probably lay down guidelines for our future. And I'm sure with all of you participating and the eminent panelists coming up, we'll make a great success of this convention. In the early morning, let me thank you for being here and welcome you all to start this new Rule of Law Convention. Thank you very much.
Now may I request Mr. Shyam Devan to give his address?
A very good morning to each one of you. Justice Dinesh Maheshwari, Judge, Supreme Court of India, Ms. R. Venkatramani, Attorney General for India, my distinguished friends on the dais, Prashant, Amarjeet, Mr. Chandiok, distinguished ladies and gentlemen who've traveled great distances to be here, law students, young lawyers, may I add my couple of words of welcome to each one of you, particularly those who've traveled distances. Welcome to New Delhi. It's a wonderful city in many, many respects. I think some of you must have also already tasted a little bit of the architectural splendor which the city has to offer. Ancient architecture, medieval architecture, and wonderful contemporary architecture as well. We have some splendid gardens. There's Lodhi Gardens, very close to this venue of ours. There's Sundar Nursery. I commend each one of you to probably take out a little bit of your time and visit the wonderful gardens that Delhi has to offer. There's lots in terms of varieties and options for Indian food, and please don't miss on that experience now that you're here in New Delhi. The beginning of summer, and this is a slightly divisive issue which I speak of, is the beginning of the mango season in India. So each one of us has our great loyalties to mangoes, which are a delicious fruit from different parts of the country. My favorite is Alfonso or Afus, which comes from the Konkan region on the west coast of India. But I suspect that everyone on this stage and probably in the audience has a contrary view and a favorite which is sort of regional specific, because I suspect that our tastes develop as children and then we continue that loyalty throughout our lives. The term Vasudhaiva Kutumbakam is a Sanskrit expression, and this Sanskrit expression, essentially drawn from an ancient Upanishad, one of our Vedic texts, speaks of the world being a single family or one family. And this is, of course, very resonant, I think, with today's age when our problems span not just the nation state, but across jurisdictions, across the planet. And perhaps there's a lot to learn, and I'm sure the speakers will expand on this theme as to how the current solutions which we fashion need not be or cannot at many, many levels be local solutions. And the reason is that the world is flat, technologies are being applied, used, sometimes misused across the world, and we have a situation, therefore, where solutions have to be found as if we are a single family. And here, of course, the concept, I think, is it's sort of pregnant with philosophy. It's not just across jurisdictions in the form of physical jurisdictions and nation states, but it's perhaps also the notion of a single family across species, across situations where we wonder, and I mean there's deep-rooted philosophy in this part of the world where what is traditionally considered as inanimate, whether it is mountain ranges, whether it is flowing rivers, whether it is forests, all of these in parts of our country are worshipped. And perhaps this key phrase for our conference strikes a resonance or some sort of a chord with even uniting solutions with regard to not just across the world and multiple jurisdictions, but possibly across species as well. The theme also has a resonance to the United Nations Sustainable Development Goals, which you all know must by 2030 be adopted and attained to the extent possible. And SDG 16 is particularly of relevance to us because SDG 16 calls for peace, justice, and strong institutions. And I commend the organizers of today's conference for having melded the theme of the conference with this global agenda where we seek and work towards strong peace, justice, and strong institutions, which obviously includes promoting the rule of law at both the national as well as the international level. I think there is a huge amount of work here to be done, not just at the level of individual lawyering, but also a role for bar associations. And I can see several leaders of the bar from several jurisdictions present at this conference. And I commend you to sort of put on your thinking caps as to how we, as members of the bar and as members of the organized bar, can contribute towards building stronger institutions to attain this SDG 16 goal. There is a great jurist of this country was a senior advocate who argued some of our most influential cases, Mr. Nani Palkhiwala. And last night when I was preparing a few points for this talk, I happened upon an article which he wrote in January 1977 on the retirement of one of our great judges of the Indian Supreme Court, Mr. H.R. Khanna. And this is what he said: "So long as there is a judiciary marked by rugged independence, the citizens' civil liberties are safe, even in the absence of cast iron guarantees in the Constitution. But once the judiciary becomes subservient to the executive and to the philosophy of the party for the time being in power, no enumeration of fundamental rights in the Constitution can be of any avail, because the courts of justice would then be replaced by the government's courts." I can state with mild confidence and a tinge of optimism that in India at 75, since that's the number of years since independence, we continue to have courts of justice and not government's courts. Nevertheless, it remains a constant endeavor on the part of citizens and their lawyers to widen the door of liberty where it is being shut, to stick a wedge into statutes that concentrate state power, and to push back against the intolerable epidemic of statutes that discard the presumption of innocence. In championing the rule of law, we must value distrust. Unless we retain a healthy distrust for the state and its organs, we may slip back, as we did in India during the spurious emergency between 1975 and 1977, and slip into a dark abyss. With a seventh of humanity in this nation, that would become a tipping point as far as planetary freedoms and liberty is concerned. So building institutions through the rule of law will mean not just an independent bar and independent judges, but also an informed, educated, and independent frontline protectors, namely the bureaucrats, the police investigating our cases, and of course the integrity of our prosecutors. So there's a huge amount of work to be done in terms of attaining the SDG 16 goals. And my final point is, I was introduced as President-elect of Law Asia. I have mentioned this to some of you as we met yesterday and this morning. There is the Law Asia annual conference in Bengaluru this November, between the 24th and 27th. And I request all of you to enrich yourself not only from the deliberations of this particular Rule of Law conference, but also the event which we are planning in November. Thank you very much, and do enjoy the mangoes.
Thank you, sir. May I now request Mr. Prashant Kumar, the President of Bar Association of India, to give his address.
Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India and Chief Guest for today's inauguration ceremony, Honorable Mr. R. Venkatramani, Attorney General for India, and he is one of the rare poet Attorney Generals of India. He is known as much for his poetry as his legal acumen. And my colleagues, Shyam Diwan, Mr. Chandyok, and Amarjit Singh Bedi, and all the foreign delegations. India is having G20, and the Bar Association is having its own G20. We have 20 countries represented here. And it is due to all of you who have taken the trouble and initiative and honored us by accepting our invitation and coming here. And I hope you will have good time here, good deliberations, and all of us will leave these 2 days enriched and learning a new few things and knowing about each other more, making more friends, because that is how the entire human society proceeds further, by forming relationships. Now, what is rule of law? There are several definitions, but ultimately, rule of law at the core is having systems which order human relationships and transactions at the state level, at the international level, and how all these relationships are conducted harmoniously and for mutual benefit. So at the state level, it is the institutions of governance, as Shyam has already spoken about, that UN has the agenda, SDG 16, to strengthen the institutions, especially relating to the justice. Now, the other aspect which Shyam has also spoken about is whole world being a family, Vasudhaiva Kutumbakam. And that is where the conception of rule of law, which is today measured, applied, and thought about mostly in terms of nation states, transcends the nation states' boundaries and has to come to apply to the international relations, how humanity, which is now borderless. You have visa norms, you have this thing, but now modes of travel, increase in business, trade, cultural interactions is creating a unified humanity. And that's why these core values of rule of law must also apply how internationally the relations between the people, people to people, and the nation states are ordered. Now, at New Delhi, when we thought, because most of the organizations, national organizations, international organizations like International Bar Association, which is represented here, and Union International, this Advocates, which is represented here, Law Asia represented here, all organizations have rule of law at its core objective. So why we are making this kind of a dialogue in New Delhi? The spur for this came from two ways. One, we find that whenever there are dialogues around rule of law at various international fora within the legal community, they always measure that how the rule of law is performing or thriving or being undermined in different jurisdictions, but the standards and the outlook and the standpoint from which all the assessments are made are from Europe, from United States, where we have history of centuries, where these institutions have formed and got roots. Then we talk about Global South. Global South, last 50 years, like India, 73 years, have come out of colonial rule, have come out and broken the isolation. The countries in Africa, in Asia, in Latin America, and in South America, all these countries, they have to have a organic growth of institutions. You just can't have institutions which have performed well in other parts of the world, but all those institutions, even brought in to the systems, they have to then grow in consonance and in harmony with the ethos, with the culture of those jurisdictions, and also the historic circumstances. So that is why we thought it will be worthwhile that we start talking about rule of law, we start having conversation about the rule of law, where we share our experiences, not just our successes, but our failures, and we learn from that. So that is the spirit with which we have invited you all to start thinking from this point of view, how rule of law should apply to us, what we have done with the institutions so far, and how should we proceed further. Now, when we talk about global indexes, comparative, how rule of law is there, and Bar Association of India also works with World Justice Project, which brings out rule of law index. But some things which, all these indexes do is to have a specialized criteria and assessment. Like when we talk about India, we are somewhat in a middling position in terms of the index. But if you keep the index away, with all the problems, with all the issues which are there, which are bound to be in a country which has so many languages, so many religions, so many, federal structures, so many state governments, and so many challenges of poverty, so many challenges of bringing people out of the poverty. So in these challenges, there have been some deficits. There is a legal system, a justice system, which is not able to cope with a huge number of cases which come to the courts, and that is what is counted as something which impacts the rating of the rule of law in India. But if we look at the other side, India has been an uninterrupted democracy since independence. Every election has seen a peaceful exchange of power, transfer of power, at federal level and at state levels. Our election commission has performed wonderfully. Our judiciary is one of the strongest judiciaries in the world, exercising the power of judicial review. And that was demonstrated in 2014-15 when the Supreme Court struck down the law on appointment of judges, a law which was passed by almost unanimity of the Parliament, but it fell foul in the estimation of the Constitution bench of the basic structure of the Constitution, and it was struck down. So perhaps it is one of the most powerful judicial independent institutions in the world. Yes, of course, it is the quality of jurisprudence, the pendency, other challenges are there. But on the other hand, if you see generally about India, and I want to look at this pendency from a different point of view, just see the resilience of Indian people and their trust in the institutions, that despite the years and years of pendencies, people still go and take recourse to the institutions. They want to go to courts to have justice, and they patiently wait for it. They know it's a big country, the system is overloaded, but nobody goes on the street. The society remains peaceful. And that is what is the glory of India, because we have not only adopted the modern institutions of governance, a constitution which is very elaborate, but also we have melded it with our own cultural ethos, with the values of Indian people, and how they have for centuries lived together and assimilated every race, every this thing. India is perhaps one of the countries which has allowed all the races and people to come to India. They were welcomed and never forced to change their religion or their ethos. They were provided with an environment to retain their culture, retain their religion, preserve their cultural practices. So that is how it is the centuries traditions that have sustained the rule of law and the institutions here, not just the structure of the institutions or the legal frame behind it. So this is how we find that each country has its own unique ethos. Like we have South Africa here, and after apartheid, dismantling of apartheid, there was a Truth and Justice Commission. That came from the cultural ethos of South Africa, and it was a successful experiment. But then we were in Sri Lanka, and after the Tamil War and the political stability came, one of the ideas was whether in Sri Lanka for the Tamil and Sinhala reconciliation, the South African model can be adopted. But ultimately it was thought that the South African model came from the very unique tribal cultural ethos of South Africa, and it may not be possible to implant it, lift it and implant the model here. So that is what we are making an endeavor. We want to understand each other, and we want to feel proud, encourage each other that we develop systems. They may be deficient somehow, they may be having the challenges, but having conversations, having understanding, and making them in the image of our own cultural identity, our own history, our own values, and our own priorities. And lastly, I will say that whatever the other things are, India's biggest success lies that from 2005-06 to 2020-21, in the World Poverty Report, India has been successful in bringing 473 million people out of poverty. And that is what I say is a symbol of a very healthy rule of law. Because without justice, without social equity, none of these things could have been possible. So as we always strive and continue to strive to improve ourselves, to face challenges in more robust and bold manner, analyze our own deficiencies, which is a must to improve ourselves, but at the same time, we must assess our core strengths, and we should bind our core strengths with our priorities and work with other friends and see that world becomes a better place in terms of application of the rule of law, its core values and principles, which ultimately promotes human prosperity, human well-being, social equality everywhere on this planet. Because ultimately, with the water, with energy sources, everything which is finite, there is going to be more challenging scenarios when the populations are increasing, climate change is there. We have to learn to live together. We have to see that everybody gets what they deserve. Otherwise, like the pandemic, that COVID virus spread in no time all over the world, these tendencies where populations who are deprived, who don't have means, who suffer want, who suffer deprivation, that can also spread as a contagion throughout the world. And we know even in developed countries, we have some symptoms whenever some benefits are taken away, the rule of law breaks down. There is violence, there is challenge to the authority. So we have to think together, we have to work together, and we have to take it forward. Thank you very much.
Thank you, sir. I'm sorry, I've just been told, so there is lighting of lamp. May I request Honorable Mr. Justice Dinesh Maheshwari and our Attorney General please to come and light the lamp, and all our members on the dais please come and assist that.
Lighting of the lamp is an Indian tradition related to knowledge, because the knowledge is ultimately the light of knowledge drives away the darkness of illiteracy, the darkness. So that's why lighting of lamp is always carried out for every auspicious function, to remove the darkness and to bring light.
Thank you. Now may I request our guest of honor, Mr. R. Venkataramani, our Attorney General for India, to give his address.
What a wonderful initiative Bar Association of India has set in motion. On behalf of the Indian legal fraternity, my friends on the dais, and my very esteemed friends here in the audience, Mr. Vaidyanathan, Mr. Naganan, the Advocate General of Kashmir, Mohit Mathur, and many others who are part of this think tank of India, if I may call it, are here to welcome people who have traveled from all over the world. Way back in 1783, two convicts who were convicted and imprisoned, sentenced to death in England, by a chance of destiny, were transported to New South Wales. And a husband and wife, they got married while they were in jail. And it so happened, instead of being transported to America, they were transported to New South Wales. And New South Wales became the first convict colony of England. And when these two persons who got married in jail, and the woman gave birth to a child, and fortunately they traveled together. So they landed in New South Wales after about 8 long months of journey. They found that the belongings of this couple, which included a lot of charitable contributions gathered in England, did not reach New South Wales. And they had a problem. And where did they go? The first civil court and a court to look into the wrong of a captain of a ship was convened. And the court ordered in favor of the return of the belongings of these two couples. And a wonderful book is written on rule of law in a penal colony. So we have those examples of human civilization wherever they landed, to lean in favor of and to clutch those very important elements of human civilization, namely rule of law. Why I cited these penal colonies, I'll come back to it a little later. Is the world on fire? Have the promises of free enterprises in collaboration with science and technology to generate hitherto not witnessed social resources for being accessed by all peoples, fallen into traps and challenges, and thus seem open to question? How far an experiment in fusion of extreme political control and regulated economic freedom as communist China has embarked be replicated at all as the answer to social evolution to rid of inequalities? Are we to ponder on new forms of collective governance where freedom, creativity, and innovation are the basic driving forces of human flourishing? will and can coexist with claims for equal regard in all respects and equality in life pursuits? Thomas Piketty argues recently that we need to talk about a new way of going beyond capitalism, a new form of socialism, participative and decentralized, federal and democratic, ecological, multiracial, and feminist. 100 questions confront us in unraveling answers to these and connected issues beyond quarrel or debate. The very unique endowment of humans in explaining the world through its experiences is also the treasure trove to be wisely handled. Do we need more and more of political regulation as frontiers of our freedoms expand? Or should we simply manage alliances with technology to have answers to these subjects? If power is what is generated by us in collectivities, in consent or coercion, and as said therefore, has protean and diverse forms and faces. Power is thus what we politically experience, whether as order, democracy, authority, subordination, capacity, possibility, or containment. Powers without their glaziers. This choice is as hard as we cannot forsake hunger and inequality. The imperatives in choosing sustainable life meanings and practices is an urgent question. Similarly, about technology and its redemption promise. A perspective study puts it like this. 4 pictures of law are considered. 2 are traditional pictures, law as order and law as just order. And other 2 are prompted by technological disruption of law. Law as governance by machines and law as self-governance by humans. Tim Berners-Lee, who is credited with creating the World Wide Web, said this, I quote, "As we are designing the system, we are designing society. Ethical rules that we choose to put into the design impact society. Nothing is self-evident. Everything is to put there as something that we think will be a good idea as a component of our society." I quote. Professor Ursula Franklin argues in her book, The Real World of Technology, thus, technology is not the sum of the artifacts or the wheels and gears or the drains and transmitters. Technology is a system, but it entails more than its individual material components. It involves organizations, procedures, new words and equations, and most of all, is an agent of power and control. Quote. Are we going to be a world without mind, going about our lives in isolation in the private worlds of technology and public transformation of our life, social and economic order, with our thoughts on equality and equity, and resigning to solutions that may come from inadequately informed governance institutions and judicial reach? All these are rule of law questions beyond traditional matters such as democracy, independent judiciary, and accountable watchdogs. Historians hold mirrors unto us as if helping us to learn about our protean past and chart our destiny on this planet based on lessons drawn from the past and across civilizations. Whether it is dialectical materialism or any other school, the offer assists in planning our future. Since we cannot have a time travel machine, unlike the time machine of H.G. Wells, capable of going back into our past and traveling into the future, we look into as much as history can teach us. Recent history in the post-Soviet Union era, the constitution-making exercises in Eastern Europe, alongside the ethnic clashes here, the upheavals in Islamic territories, including the US presidential debates around both the Bush and the Trump elections, valuable lessons for taking stock of the importance of the rule of law and the debilitating factors such as culture and policy. In the sense, history is one tool of rule of law. Each age of our shared history has organized forms of governance, of being together, while growing differences and distinctions. In different ways, the superior binding relevance of some code, law, morality, dharma, and so on has been emphasized, entailing the supreme value of governance under some code of conduct. All nations and civilizations across geographically connected cultures bear this feature. Volumes have been written on how violence has been the way to resolve multitudes of differences or invoke social, geographical, religious hegemony. Optimists, however, predict that violence as a means of going around a problem is on the wane. We can attribute this significant decline in violence to many factors: the decline and end of colonial occupations, the decline and end of religious colonization or hegemonical ventures by force, the decline and end of national wars, the emergence of the idea of constitution and representative democracy, the emergence and entrenchment of ideas of right that can be enforced through impartial tribunals, particularly human rights, civil, political, social, economic, and cultural. And maybe we can add more to this list. Two propositions are made here. One, that rule of law is the antithesis of all coercive authority, which impedes or interferes with the profundities of life and liberties. Two, that unlike revolutions witnessed by Europe or elsewhere, the non-violent revolutions of the rule of law is the more nuanced genius of human prospect on this remarkably ordered earth. It does not matter the rule of law is hijacked by both sides in a debate, as it happened in the case of election debates surrounding the Bush election. The attempt made here is to ask questions and spread them, then drawing a final catalog of checklists for the rule of law. Therefore, can there be one all-embracing concept, definition, or comprehension of the rule of law? Is the rule of law evolution an amalgamation of several political and social ideas, ultimately tuned to limit and tame all arbitrary power, private or public, in all their emanations, manifestations, and practices? Is it more closely connected to the institutionalization of all social and governance processes so that justice, equality before the law, and accountability to power are secured by rules and made through community participation and publicly enforced? Why do we need the thin and thick varieties of rule of law, and what do they conceal? Political ideologies dressed in new clothes? On the thin conception, note what John Rawls, among others, says. On Rawls' view, I quote, rule of law is simply the conception of formal justice applied to a legal order or a system. Formal justice, in turn, is a thin, non-moral principle of reason addressed to rational persons to regulate their conduct and provide the framework for their cooperation. As to the thick notion, note what F.A. Hayek holds, I quote, when you obey laws in the sense of general abstract rules laid down, irrespective of their application to us, we are not subject to another man's will and therefore free. Because the rule is laid down in ignorance of that particular case, and no man's will decides the coercion used to enforce the law. The law is not arbitrary. Quote. Several statements on the high ground of law and subjection of all people and relevance of rights in securing them have been made in the past. Remember the famous statement made by H.L.A. Hart that where there is law, the human conduct is made in some sense non-optional or obligatory. All such statements are made in the context of diverse historical backgrounds and social orders. Is it not that they are either partial or incomplete for current universal global reception in view of the neoliberal economic spread and technological-driven globalization, which poses several unprecedented global and local challenges? The coalescence of the nation-state with the market state, the domestic and international management of the new avatars of global interactions, call for multiple blueprints of action. The growing inequality in terms of accessing resources, socially generated, namely economic and livelihood resources, education, culture, justice administration, and health, and their entanglement with the rule of law is again a subject of deeply divided opinion. Or is it that we need to acknowledge multiple conceptions of rule of law with common denominators and additional layers of significance? The following observations apply the quick critique of formal proposition, the rule of law. The more the theory of the rule of law is desubstantivized to embrace only those institutional forms that have such values associated with the formal rule of law, the more likely it is that the formal rule of law will receive its due. On such a politically neutral conception, far more people from all segments of the political spectrum can be enlisted to support the rule of law and to criticize departures from it. From the aerial scan of what is attempted above, I wish to say that only through a non-violent social processes that are closely affiliated and converging in the rule of law that can be proclaimed a truly fair social order, where human wealth of the cooperative production of all is the wealth of the community for all, where property as a social relationship will be a matter of resource management and not of unfettered control of being and life of others, where freedom of thought and conscience of the individual will be valued as a measure of the community's ability to promote and manage individual liberty, and where individual liberty will be the common quality of humanity and will not vary with chances of birth and status as it obtains today. Thus, there is an intense inquiry and search for human fulfillment and well-being that can be attained through higher and legitimate levels of governance and consistent with freedoms in all dimensions of life. Freedoms, when self-nurtured and internally organized, attain nobility. When freedoms seek to run riot, hissing dangerously at any regulation, governance gets debilitated. So also, when governance becomes a juggernaut wheel or yields to sinister interests, it is cancerous. Adjectives are therefore sometimes added to supply emphasis on the quality of governance, and thus we talk of good governance to mark some distinctions. It is not enough, as perceptively stated, to offer rule of law assistance standard menu. It is instructive to read critical statements on what is referred to as the rule of law assistant standard menu. The menu, according to the scanning eye, includes reforming institutions, judicial reform, strengthening legislatures, police and prison reform, etc., rewriting laws, modernizing criminal, civil, and commercial laws, upgrading the legal profession through support for stronger bar associations and law schools, and increasing legal access and advocacy through the support of legal advocacy, NGOs, law school clinics, and so on. The rule of law is not something that exists beyond culture and that can be somehow added to an existing culture with a simple expedient of creating formal structures and rewriting constitutions and statutes. In its substantive sense, the rule of law is a culture, and the human rights law and foreign policy communities know very little and manifest little curiosity about the complex process by which cultures are created and changed. We are called upon to defer ecology dictates and therefore explore more seriously than ever sustainable development. Deep debates on development have encountered what constitutes indices of development and the new global scales of uneven human standards of life, while representative democracy and the political power competition seem to inject periodic vigor into the lawmaking processes, social and cultural factors also try to capture a good bit of the show in many countries. In a nutshell, we seem to be at crossroads. Either we hold that rule of law debate is no longer confined merely to controlling arbitrary power through the supremacy of law, repeating the importance of equality and cataloging rights, or we stand by the emerging demand that rule of law must get into fundamental questions of political processes through which rights, duties, expectations, and needs are debated and administered, constitutions abided by, discretions and public policy choices are open to correction, and that no dispensation of any sort are made under cover of assumed wisdom of any system of economic ordering. We will not be merely discussing impartial courts, fair trials, known laws enforced through known and published procedures. We may have to march ahead of propositions on the rule of law drawn by institutions like the World Bank, though not turning them down. While I wish to read the rule of law evolutions propelled by the instinct against non-violence, amongst other factors seen above, I also wish to understand that a social order, which is blind to the ideas of right and duties of each human being, moderated by every age, is a non-rule of law social order. Each of us creates, makes, sustains, or annihilates individual and collective lives, social orders, and the world that sustains us. For the rule of law, what would matter is how these functions are enabled, injuncted, and regulated without sacrificing creativity and innovation, and blended with equality and equal regard for all life. The womb of Magna Carta carried the seeds of rule of law partially. It awaited more motions towards democracy before economic liberty became a crucial factor in the rule of law. Only the great lessons from the fields of blood, strewn by human violence, have told us that the highways to justice are to be learned from non-violent rights and duties conjunction, and the ladders of rule of law are to be built brick by brick. Again, while it is invigorating to read great minds like Professor Upendra Bakshi or an American academic like Professor Brian Tamanaha, drawing our attention to the unlit or ignored corners of our focus, it seemed that we need to tie together seemingly unconnected threads, namely substantive versus formal theories, social justice versus freedom and the market states, culture and obedience to law, globalization and the surge of technologies and so on. We notice in a way, earlier the rule of law is not about the static affairs of governance within a static framework. It makes sense to talk about the movements of both people and governance towards qualitatively superior functional parameters relating to matters such as community participation in governance, access to justice, and equal application of laws, non-arbitrary criminal law and prosecution, accountability of all public institutions, freedom of expression, regulatory institutions, and their efficacy, corruption, and so on. We thus say that it is not mere stability of governance that symbolizes the rule of law, but the distribution of power and normative dispersion of all socially generated resources. It will make superior sense when we constantly embrace novel approaches to dying systems or do not fetter our norm-creating abilities by the treadmills of the past. All revolutions, however rhetorically grand, have disabled themselves by post-revolutionary aberrations, by ignoring even the basic rule of law norms and burying the instincts of truth and justice. The dogmatic belief in superior ideological narratives, namely socialism or unregulated markets, has shown the yields of sufficient strength for all governance. The profound word coined by Gandhiji, satyagraha, encompasses many shades of meanings and can marry well with rule of law. It's an appeal to people and governance to be ever in search of truth and justice, and what more can be closely engaged to these and the rule of law, understood as the non-violent evolution of social orders. Since Prashant mentioned to me about partly being a poet, during this lockdown when many of our minds were closed and within limited frontiers, a few thoughts which came to mind. I penned down, I thought it may be of some symphony with what you're talking about, and with your permission, let me read it. The title is, Why Are You Waiting? Why are you waiting? The long arms of the clock never stop ticking. Roll up your bed with stains of the past. Close up your lens with lines too dark. Close all the books so dense in the libraries of your mental shelf. Shed all the truths you learned in divisions kept us for too long. Why are you waiting? The leisure you had in the past is dead. Few are in comforts, many are in pains. All your thoughts and codes of rules, which worked in paces slow and sloth, or in trial before a court too strong. Equal all we cried a lot. Equal all we wrote a lot. Equal all we thought a lot. In leisure we sought answers a lot. Nature, God or what you may, is drawing lines on what you can. Nature, God or what you may, is showing holes in your thoughtless spots. Law and justice, goods and markets, fair in new scores, shared in new ways. Looking back you dare not do, to rewrite old ways in phrases new. Why are you waiting? Ideologies and histories old will tell you all old is gold. Mind be young, mind be free, mind be strong, and be a midwife of new songs. Race and caste, and all those wares which choked our nostrils and choked our lungs, are Bronze Age brittle mental wares. Rewrite your rules, rethink your ways, relook your thoughts, reload your minds. Why are you waiting? Thank you for all your attention.
Thank you, sir, with the poetic ending. Now may I request our chief guest, Honorable Mr. Justice Dinesh Maheshwari, to give his address to us.
Thank you. A very good morning to all. It has been a wonderful and a sweet start of this particular program, where Mr. Shyam Diwan started with indicating the sweet mangoes to all of you, introducing. But as a senior lawyer as he is, he can simply put a proposition and leave everything else for the judge to decide. And the judge, as I am, so I asked him, where is the sample and where is the proof? So I hope if me not, all of you will get not only the sample, but real sumptuous treat here, the Indian fruits, which include not only mangoes, as Mr. Diwan is fond of. There are much of sweetness, not only in fruits, but in several other features all around. The country that is India, that welcomes all of you with warm hearts and all sweetness. When Mr. Diwan was talking about mangoes, I was reminding myself about the season of pineapples in Far East Meghalaya. So, well, there are varieties available in the landscape of this country. Similarly, so far as the principles and the conceptions of rule of law is, and the global order, the global governance order centered on humanism and values and principles of the rule of law and anchored in strong, independent and efficient legal and justice systems. That is the theme framed of this convention today, based on the concepts, the fundamentals of Vasudhaiva Kutumbakam, the basics of the Indian ethos, believing in the world to be one family, and rest all follows and flows from that alone. There was a ceremonial lighting of lamp. It's another fundamentals of the ethos of the Indian society is stated in the catchwords Tamso Ma Jyotirgamay, and it means take me from darkness to the light. And that is a prayer, that is a fundamental prayer. What we mean to say, what we mean to pray is that we keep on proceeding towards a better order, whatever are the challenges, whatever is the darkness. Thank you. Mr. Prashant Kumar indicated that we have the delegates from 20 countries here. While we welcome all of you, thank you, this year when India is hosting G20, there are quickly several of the 20 things come to our mind, which include the conversion of a relaxed game of cricket from test matches to T20. And with that, if you just pause, and as was being indicated by the learned Attorney General for India, 2020, the year 2020, had been an year of challenges for the entire humanity, for all of us. An unknown enemy, unseen enemy, had attacked the very existence of the humanity. But we all know the world stood together combating something called the COVID-19 pandemic. The adversities were manifold, the challenges were manifold, but out of every challenge, the humanity came out stronger than before. So, 20 has several lessons for us, and 20 gives us very many possibilities. While welcoming the delegates from the 20 countries, I'm very sure this particular convention is going to go a long way in redefining our thoughts as regards an inclusive global order where even the terminologies of globalization or glocalization, they would be the things of the past, and we would be proudly saying to ourselves only the fundamental phrase, that is Vasudhaiva Kutumbakam. Friends, several things you would be discussing over the time in this convention for these 2 days as to how to integrate ourselves and then how to march ahead. And that is obviously going to have focus on the economic activities. And coupled with that would be interwoven the activities of dispensation of justice, because dispute resolution would always, the arising of dispute and then resolution of dispute will always remain a part of the requirements of any progressive order. When we talk of rule of law, there's several angles to that, several aspects of that, the fundamental theories of that, as were indicated by the learned Attorney General. And we all students of law keep on admiring those theories, how they have developed, and we keep on developing on them. I'm not here further to add on to that. You are going to discuss about those theories and how we go about further on that, but want to underscore one particular aspect with reference to, in the Indian, particularly with reference to the working of the Constitution of India and with reference to the Indian context, which definitely would be a guiding factor for appreciating as to how the rule of law, and for that matter, dispensation of justice through the adjudicatory mechanisms, particularly the courts, and of course the other mechanisms which are indispensable now, is fundamental to maintaining the rule of law. An example, friends, as it was being indicated by preceding speakers, about the basic structure doctrine that was evolved by the Supreme Court of India, particularly dealing with the questions relating to the validity of any amendment to the Constitution of India by the Parliament. It's a wonderful study for the students of law, for all of us, that the basic structure doctrine was evolved starting from Keshwanand Bharati, but interestingly, out of the 7 instances when basic structure doctrine has been applied to disapprove a constitutional amendment by the Parliament, at least 5 times out of those 7, it relates to judiciary, judicial review, or independence of judiciary. Keshwanand Bharati, Minerva Mills, Sambhamurthy, essentially relating to judicial review. The Supreme Court did not approve any tinkering with the powers of judicial review. NJC judgment was just now indicated, again, that related with fundamentals of independence of judiciary. L. Chandrakumar, another decision, plenary powers of the constitutional courts, sought to be tinkered with, not approved. Even the other decision of Keleho, although the constitutional amendment was struck down on a different ground, but that also related with the powers of judicial review. It has been one instance where the free and fair elections were in question, that the basic structure doctrine was invoked, and else, even when Parliament is otherwise allowed to amend the Constitution as it deems fit, as requires the necessities, when it comes to anything related with dispensation of justice and adjudicatory mechanisms, well, anywhere anything which is sought to deprive the citizens, sought to deprive the society of free, fair, independent judiciary has been frowned upon. Another unique feature that my learned delegates from the foreign jurisdictions being here, I'm tempted to indicate. Another unique feature of the Constitution of India is not only the fundamental rights of Part 3, but very interestingly, taking recourse to the court in the case of violation of fundamental right is itself a fundamental right. That is Article 32, the students of law are aware of that. But elevating the right to relief in the violation of fundamental rights, elevating that right itself to a fundamental right is a unique feature. And that is how we can be absolutely sure that rule of law remains fundamental to the Constitution of India, in the sense that any attempt at any violation or any tinkering with rule of law is going to be dealt with by the systems and the mechanisms provided. Friends, mango, as I'm tempted to repeat it again, was being talked about. In India, mango is considered to be the king of the fruits. Maybe Mr. Shyam Diwan might be finding it troublesome. Anyway, but it's a treat for all of you, I'm sure. Mango is regarded as king of the fruits. The point is, king in the concept of the civic society, the sovereign, the ruler, whosoever be the king, the concepts had been fundamental in our country, India, that even king is subject to the law. He is not above the law. Law is above even the sovereign. So the rule of law, even in the context of the king, has also been ensured, maintained. Rule of law takes its different shapes according to what is required, according to what at a particular point of time the social order needs. The concept always remains that there are principles. There are principles which are applicable across the board to everybody, irrespective of his status or positioning in the society. Friends, principles have evolved. The principles are evolving, and now with the new global order, where boundaries, so far as the nation's boundaries or any boundary drawn on the globe, have become redundant, are becoming redundant. In this world order, for the purpose of proper progression of the humanity, fundamentally the human beings themselves, the trade, the commerce, and then taking care of the challenges like the climate changes, or these days the cyberspace challenges, the cyber crimes. What remains fundamental in ensuring the rule of law prevailing to any particular smaller unit or to the largest unit of the globe is our commitment, the commitment of the human beings to the principles which are fundamental to the maintenance of the civic society. The exact words rule of law are not found in our constitution and would be less found in other constitutions also. But the concept remains implicit in our constitutional provisions also. The Constitution of India envisages power and authority flowing from the Constitution itself and then distributes these powers among different organs of the state. This again ensures that there is no concentration of power. As I said, it is reflected in the judicial review powers also. Now, coming to the international and the world order, there are two specific categorizations. First is the international law by itself. It could be termed as international law proper and is a rule-based international order. This rule-based order is already in existence and it guides the interactions between the state. The second, and perhaps the interesting categorization, would be the expansion of rule of law in this globalized world, which takes into account the evolving conceptualizations across jurisdictions, which has been described as law diffusion and reception. Given that there are so many emerging areas of law that would require a cross-comparative approach, and also considering that the nature of crime has moved beyond borders and jurisdictions, there is need of law, the need for the rule of law to transcend the national boundaries. In these areas of concerning arbitration, trade law, environmental law, cybersecurity, now there is an emerging need for a translational approach to the rule of law. And in that context, well, India is playing a vital role in shaping this discourse and has the potential to take the things forward and further, well, to ensure a well-meaning and a constructive global order. Friends, this convention today is going to go a long way in shaping our thoughts. I'm very much sure. There are so much to learn and then to assimilate the best practices around the world, and that leads to the capacity building as one for all and all for one, and we go on proceeding further. There are rapid changes these days coming up, including as recently a couple of weeks back, the Bar Council of India has started to open up as regards the involvement of our foreign friends into the system of, proper advising the litigants or the person in need of advice. Of course, the things shall be taking their own shapes, but it's a beginning and it's going to go a long way, and ultimately making, I could say for sure, that India is a hub for international trade, commerce, and arbitration too. Friends, India has already established several institutions to promote international arbitration, such as Mumbai Center for International Arbitration, the Delhi International Arbitration Center, and the International Center for Alternative Dispute Resolution. These institutions have provided platforms for resolving international disputes and are becoming increasingly popular. I'm sure in the coming days we are going to have more of the institutions playing their important role in combating the emerging issues of cyber crimes and technological, and out of those technological developments. Friends, the learned, since you have several sessions to go, I want to be standing now between you and those sessions. The learned Attorney General for India, as he was introduced, and rightly he proved also a great poet in his own rights. Frankly speaking, the poetry is not my forte, and I can only recite or try to recite out of a few things which we learn. I was tempted to take note of and to share now today with this audience, to underscore my points which I indicated in the famous poem of Gurudev Rabindranath Tagore, where mind is without fear. And I just recite it. It goes as follows: where the world has not been broken up into fragments by narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Tagore's vision for India can and should be extended to encompass the entire world. Narrow domestic walls must be broken in favor of a shared global identity that promotes tireless striving and ever-widening thought and action. Thank you so very much, friends.
Before I give my vote of thanks, we have a surprise. We have members from the Udaipur Bar who like to felicitate Honorable Mr. Justice Dinesh Maheshwari. If I can request them to come on the dais, please. Just for background, His Lordship is from Udaipur, and the bar members have specially come all the way to felicitate him. Thank you. So to conclude this inaugural session, I like to give my vote of thanks to Honorable Mr. Justice Dinesh Maheshwari for gracing us with his presence today, giving the impetus to the convention, and on a sweet note, ending it with Gurudev's few lines which inspire all of us, and we are all so obliged that he has given the necessary strength and the starting for all of us in the next 2 days to enjoy this convention. So I thank him from the bottom of my heart. I also thank our Attorney General for his such an insightful and well-researched address that it was a learning experience for me personally, and I'm sure all of you have taken benefit of it. And also mixing with his few lines of poems that he shared with us. So I'm so thankful for that. I also like to thank our President, Mr. Prashant Kumar, because he's the one who conceptualized this convention. And this is the first convention, the New Delhi International Rule of Law Convention, which we hope to have every 2 years. So we want to go from strength to strength. And it is thanks to him single-handedly that all our foreign friends could come on such a short notice personally. So thank you so much. I'd like to thank Mr. Shyam Devan, President-elect of Law Asia, and on the sweet note that he has started the convention, the mango has become the theme. In India, we also have a word, Mango Man, which is Aam Aadmi. We are all Aam Aadmi, and we thank him for that. And we thank our President-elect of Bar Association of India, Mr. Amarjit Singh Chandiok, who has supported us for setting up the convention in every way, which way we wanted his help. He was always there day and night. So thank you so much, sir. Now, I especially like to thank our international delegates, our friends who have come from all across the world. And I know it is going to be a bit lengthy, but I need to name each one country that has come from the 20 that have been named. So if you can just bear with me, I like to thank them. I like to thank friends from United States, Israel, South Africa, Azerbaijan, Brunei, Singapore, Uzbekistan, France, Malaysia, Russia, Italy, Belgium, Japan, Honduras, Cambodia, Taipei, Dubai, Germany, Nepal, Sri Lanka. Thank you so much, each one of you. Your presence has made this convention, the beginning, the starting, such a success. And I'm sure each one of us will learn and exchange thoughts and exchange ideas with them and take every opportunity to give our host, as we in India, we like to host our friends, make them feel comfortable and learn from them and exchange ideas. And I also like to thank our friends, our senior advocates, Advocate General from Jammu and Kashmir who's here, Additional Solicitor General who's sitting behind, but he's here, specially taken time out, senior advocates I can see in the back, in the front who have taken time out, Mr. Mohit Mathur, President of Delhi High Court Bar Association, who's here, and so many other friends, each one of you actually. Thank you, thank you, thank you. Because of you, this convention is the success that we are going to see. Thank you so much. I'll just like to conclude now that we have a tea break now because our program was supposed to finish at 11:30. So I'll just request if after this we can have a quick tea break and then come back. The session starts from here only in this hall. Thank you so much.
Very good afternoon to each one of you. This is the sort of first of the business sessions. My name is Shyam Devan. I'm chairing this, and it's a great pleasure to be co-chairing this actually with my colleague Rachna Srivastav. We have 4 distinguished speakers apart from Rachna, and we'll set the ball rolling. We're running because of the enthusiasm in the earlier session and the presentations, a little over time. So I'm going to request each of the speakers to address us for about 12 minutes, if that's fair. And then if there's some further time which is available, We will take questions and interventions from the audience and from the delegates. Thank you very much for joining us. I had a little problem with the pronunciation. Is it Jorg? Okay, Jorg has also now joined us. So I'll turn this over now to Rachna. We thought we'll interleave the speakers, the home-based speakers, the speakers from India, with our guests and international delegates. So we were thinking, I'll leave the order to Rachna. She will introduce each of the speakers with a short reference to the bio, and then I'll request each of the speakers as their turn comes to address us with their experiences for around 12 minutes. Rachna, over to you.
Thank you, Shyam. Good afternoon to you all. The working session 1 is about the topic placing humanism and values and principles of the rule of law at the core of global and national governance order to achieve the ideal of one earth, one family, one future. That is the theme of our convention also, Vasudhaiva Kutumbakam. The first speaker that I am going to invite is Shri Vikramjit Banerjee. Mr. Banerjee is the Additional Solicitor General of India. He is the senior most but the youngest Additional Solicitor General of India. Mr. Banerjee was also previously Advocate General of State of Nagaland and is alumni of prestigious Law College of Bangalore. Mr. Banerjee has many feathers, but he said don't count all of them right now, keep it for later function. So over to Mr. Banerjee.
Thank you. It's a pleasure to be here. It's an honor to be here. And it's a wonderful audience and such eminent people. It's an honor to address all of you here. I have the presentation which I want to make is, broadly the topic is humanism and values and principles of rule of law and how they can be part of the national and global legal order. There are 2 points which I think which needs to be addressed. And before I say this, it's my sort of personal views on it. It does not in any way reflect upon what the government holds. So that's the caveat put in. According to me, humanism should be a part of rule of law. It should be a part of global governance. And there can be no debate on that. However, and these are some of the questions which need to be flagged. What is now happening is with programs and computer programs becoming sentient, that is being able to understand the world, react to the world, almost think for themselves with artificial intelligence. The question of bringing humanism back into rule of law becomes a difficult process. Information technology itself is something which, the challenges which face humanism today to be at the forefront of rule of law in the global scenario are manifold. One is because of the presence of social media, it has enabled in many ways all of us to express our views very freely. It has also ensured that there can be actors who may use this freedom, or should I say misuse this freedom, in order to influence the course of action in different societies. And they may not be in your country, which then actually impacts the society in which we exist. Second, this has also led to responses from the state to carry out greater and greater sort of surveillance, to ensure that the freedoms which are guaranteed as part of rule of law and liberties which are enshrined in rule of law are not misused. This is a challenge like no one else. And ironically, while we today discuss this entire question of humanism and inserting humanism into rule of law, and which we think should be given, it is becoming more and more of a challenge to bring back humanism to a process which is being taken over by, in many ways, by mechanisms and artificial intelligence and the internet. The space of inserting humanism into the rule of law is becoming lesser and lesser. Another aspect which I want to flag is the question of use of biotechnology. As we all know, that there have been great advances in biotechnology, which has led to, for the want of a better word, for some sort of experiments which have resulted, which or can result in consequences which are very extensive. Last few years, we've been all shut at home at certain points of time, and our liberties have been greatly curtailed because of the nature of a global pandemic. Now, the input of science into this global pandemic and whether science itself was responsible for this is another question. And whether such science can be used to disrupt societies is a further question. The response of the state, therefore, has also been to cut down the liberties in order to protect the health of the society at large. So, ironically, while we are today discussing humanism and we live in a globalized world, and where we would have expected that there would be humanism right at the forefront of any globalized world, we see that globalization, ironically itself, is throwing up challenges to bringing humanism into the process as a part of governance. Second point is, when we discuss the questions of rule of law, what is the rule of law? I think that's a fundamental question, which I think everybody was discussing, but no one was addressing. Rule of law, according to me, and the way it exists today, where it's defined today, exists out of certain values which arose at some point of time in the West. And West as in European, Western Europe, and whatever arose out of that. Now, the conflict of that is the world has changed. The world is changing. Most people of the planet live in a non-Western world. The balance of power is anyway shifting. And for a rule of law to be truly credible, it has to encapsulate values which arise out of the non-West. For the want of a better word, I'm using a shorthand here. On one hand, this entire concept of rights and privacy. On the other hand, this entire concept of social order, of having order, and of the basis of having duties in societies. Now, for rule of law to be truly universal, it will have to balance these two concerns and not be taken away or believe that the objective of rule of law means only to create a society which exists in certain parts of the world. It has to be more diverse. Interestingly, I will just quote, two very famous legal philosophers who address this question. One is, I don't know how many of you have heard, is Alasdair MacIntyre. Alasdair MacIntyre is one of the foremost legal thinkers of the 90s, and he wrote a very famous book called After Virtue. In After Virtue, he basically proposed and very wonderfully wrote that there was, before the 19th to 20th century, there was no approximate word for the word rights in any non-European society, and how the whole conception of rights was actually thereafter brought into the lexicon of law. Now the question is, does it mean that societies were not fairly governed? Does it mean in India, where democracy has existed for 5,000 years, and it's very old, and whereas civilization has existed for 5,000 years, and recorded democracy or democratic institution existed in recorded history for nearly 3,000 years, did we not have our conceptions of rule of law? And in those conceptions of rule of law, which were primarily based on conceptions of duties towards one's society and of having an ordered society, is that antithesis to rule of law. Now, another very famous, here it's very relevant to quote another very famous Indo-Spanish theologian, very famous theologian called Raimundo Panikkar. Raimundo Panikkar wrote about, he had a very famous article published in the UNESCO publication department called Diogenes. In Diogenes, he wrote a very famous article called, Is the Notion of Human Rights a Western Concept? It's very oft quoted. Anyone who's worked on that area will know. Panikkar theorized that in Indian, and he wrote it from a uniquely Indian perspective because he was both knowledgeable in Christian theology as well as in Indian philosophy. And he wrote, in India, possibly the concept of dharma, of duties, was another way of governing society, of organizing society, and for running society. I would only propose that if we are going to truly have a rule of law based on humanism and based on a global order, then for it to be truly and universally acceptable, it has to incorporate concepts and ways and methods of organization, not only of certain parts of the world, but across the board from various different societies, especially in the non-West. Now, I have to flag an issue which was discussed, and I think that's also important. A lot of stress on independence of judiciary has been stressed as part of, as very important and integral part of rule of law. Independence, complete, absolute. According to me, both in history of even Western constitutional law, as well as in culturally, we have never treated any wings of government as silos amongst themselves. Now, and we have never treated that a certain wing of government will be completely independent of each other. According to us, unlike, again, and I'm not deriding it, certain experience of history which happens in certain Western European governments and possibly in the United States of America, we have always had a history, whether it be in the parliamentary system that we have today or whether it be Indian civilizational background, that all wings of the government actually work together to have a virtuous society. And it is important that when we talk of a rule of law, we should be able to bring all these influences together. In conclusion, and I'll conclude because we are all running short of time, when we were young and when I was in law school, it was a given, when I was your age, it was a given that, and I was there in the 1990s, it was a given that the best form of governance was free market, that we would have a future where there would be free markets and which would lead to a prosperity for all. We also believed strongly at that point of time, and we were like at the forefront of it, that the only way to have a successful society is to have unlimited rights. Unlimited rights. 30 years later, and when I'm 50, and when I got into it when I was 18, the world has changed, and experience has taught us that that may not be completely true. So learning from experience, it is important, according to me, that we view the world differently. And in this changed world, as well as the experience which we've had for 30 years, I think it's time to reevaluate what constitutes the rule of law. And if we are going to have conceptions of humanism and rule of law inserted into as a broad framework for global national governance, it is key and important that we rethink these issues and for once be inspired from, for the want of a better word, I know it's controversial, the civilizational backgrounds that we come from. Thank you.
Our next speaker is Dr. George Menzer. Dr. George Menzer is the Secretary General of International Bar Association. Apart from being an eminent lawyer, he is also a teacher. Let me inform our foreign delegates that in India, the teachers are placed on a higher pedestal than the God. So we welcome you, Dr. Menzer, please, for your address.
Yeah, thank you very much. It's a great honor to be here in India. I must confess this is my first time, but it will not definitely be my last time. Thank you for having also the International Bar Association part of this great convention. And before I start my little contribution, I want to send the highest regards of the President of the International Bar Association, Mrs. Almudena Medvedev, to you. She herself could not make it, so I took her place, and Prashant, I'm very happy that you reached out. Well, as you see and as you hear my accent, I'm somehow from Western Europe, from one of those old countries. I'm German by origin. I live in a different society. My wife is from Romania, so I since 22 years live in Romania. Therefore, I see changing structures and changing societies. I've experienced it myself. I cannot abstain to disagree a little bit with my learned speaker before me. I believe A, humanism is the basis of rule of law. I think without humanism, we don't have a rule of law. B, I agree that, yes, we have to learn from all cultures, and every culture has developed over hundreds of thousands of years, of the last thousands of years, into where we stand as a global community nowadays. But we also have to, I think, maybe I misunderstood you, be very sensitive to the notion that the society at large should or could be more important than the individual. I think humanism, for me, from a Western country, from a Germany, which experienced what it means, how quickly rule of law can be misused and turned into tyranny, the protection of the individual person, of his dreams, his rights, and his beliefs, like we here have in India, which was mentioned before, with so many different religions, is the basis of the rule of law. We cannot sacrifice the individual liberties and right to develop and to live a life how he or she or it wants to be considered just for the common good of society. Actually, there is the main struggle between the individual interest and the society interest, which we have to solve by applying the rule of law. Now, I'm sure that we will have an interesting discussion later on. Let me go back to what I wanted to say. As you know, throughout history, the thriving of civilization was always connected to the rule of law. Individuals, institutions, governments need to have the certainty of the rule of law, that the law is equally enforced and applied, because otherwise it cannot thrive, it cannot develop. That is a guarantee that our society and us individually can develop and contribute. I'm not sure if I should quote a former British Prime Minister in India. I leave that to your evaluation. However, Margaret Thatcher, who is probably quite a strong woman at head of her time, said once, "The legal system we have and the rule of law are far more responsible for our traditional liberties than any system of one man, one vote. Any country or government which wants to proceed towards tyranny starts to undermine legal rights and undermine the law." And as you have seen and was mentioned before, the World Index of the Rule of Law by the World Justice Project has been really reporting and looking at this for years, but has, especially in the last 5 years, seen a strong decline in many countries. And since I'm the Secretary General of the IBA starting in 1st of January this year, our organization, myself, I have received from 3 bar associations over the world already almost reach out, some cries for help because they are under pressure, our profession is under pressure. I find this very alarming. Why this all happens, it's very hard to say. Maybe it's exactly what was mentioned before, not only by my colleague here on the panel, but in the other interventions. It's the struggle of finding out where we as mankind really stand and what we really are striving for. What the rule of law means, at least to my belief, is A, the equality before the law. As you know, in the Indian constitution that was so prominent, reflected upon here, is one of the best examples. In most constitutions worldwide, as much as in the Universal Declaration of Human Rights, it's recognized that all individuals should be treated the same manner by the law, and all individuals are entitled to equal protection against any discrimination and violation of their rights. This seems to be quite simple, and I think this principle we all know, but maybe it's the most disregarded. And maybe it starts already in our childhood, because we all learn at home. I have 3 little boys, just came back from a short vacation with them, and we were fighting every day about the use of the mobiles. So there was a rule. Daddy said and Mom said, no, only after you have read some books, and only once you come back from skiing, and we do some other issues. Obviously, the little boys, they sneaked upstairs, searched for the iPhone. When I hit them, they took out the iPad and made find my iPhone, so somewhere it beeped and they were all running and trying to get around this rule. So we learn in a young stage sometimes to not obey by the rules that are given, and therefore we probably run in the difficulty also as societies that it's quite hard to adhere to this principle, to adhere to rules and regulations, because it's not only how they are set up at the beginning, it's especially how they are lived. And I think here our profession, the young lawyers in the room, but also us more senior lawyers, have to be there an example. We have to live up, like the Indian Bar Association does, by our own ethical standards, by our own rules in everyday life, and as hard as it is in every our actions. Now let's look at legislation. That is often a very complex undertaking. We know how politicians make laws. They are driven by votes. They are driven by their needs to be re-elected. They are driven by their beliefs and by their own ideas, which is all good and is especially, I think, a good expression of democracy to try to find the best solution for all. However, the legislative process is sometimes not quite transparent. It is done by us lawyers, by us politicians, as we today talk to ourselves. I think we need to be there aware that we have to explain the legislative process much more beyond the legal profession, beyond the universities. We have to educate the wider public and make them understand that this is also their duty to participate, but also their right. Nemo sensator legem ignorare, nobody is thought to be ignorant of the law. So just that you don't know the law doesn't really protect you. You cannot go in front of a judge and say, well, I'm so very sorry, I didn't know. Well, yes and no, because I think what I said before, the transparency and publicity of law is one of the great and important ingredients of the rule of law. Only if society, if people understand what the rules are, they can adhere to them, they can obey, and they can also share and maybe criticize. So I think we need to ensure that the judiciary has enough resources to administer the law, but that the general public also can get access to law. Pro bono projects are all over the world and also in India active. Also the International Bar Association has a pro bono committee and different programs to foster this. But we must understand that also in this room that we as lawyers are privileged. A, we studied the law. B, we are the middle class, so we are educated. And C, we therefore can also access to protect ourselves, our families, our friends, our clients, the system of law. Is that really true for everybody? Is that not very important that everybody really understands what rights he or she has? So there is a point where public needs more clarity and more involvement also in the legislative process. I know that also in India, like in most countries, at least democratic countries, law initiatives are publicized before for debate. I come, as I said, from Germany. There the process is quite transparent. In Romania, there's also public adherence where I practice, but sometimes the government publishes it on a Friday. You have theoretically 7 days for the public to give a comment, and then it's law, which obviously, from my perspective, is not good enough. Therefore, it's also about community, because if we strengthen our communities, if we really reach out, if on the village level, on the city level, we involve people in the rules and regulations of that smaller environment, they will learn and they will be feeling responsible, and therefore they will get the taste of the rule of law. Obviously, the independence of the legal profession and judiciary, which was mentioned today, is very important. What does it mean? What does it really mean, a functional judiciary? Is it good enough to be saying, well, we have a big backlog, that's it, but it's good that people are patient? I would challenge this. I think a society like the German society, Romanian society, maybe like the Indian society, needs not to accept this. It needs to really say justice can be only administered if a court proceeding takes not longer than 12, 16, 18 months. Otherwise, it loses its impact, because the moment of trouble, the moment of infractional behavior to the sentences or to the ruling is just too long. People will either give up and therefore distrust institutions, or they will partially not even start to pursue their rights as individuals. The judiciary obviously has to be independent, and also this was mentioned. I was very proud to learn about Article 32 of your constitution, which levels also the access to the judiciary to a basic right, and I think it's true. Here, Encyclopedia quotes the following: the more powerful the actors whose interests are at stake, the greater the need to protect the independence of the court from that actor. If both sides of the disputes are powerful, however, that symmetry of power may provide part or all of the necessary protection. What does it mean? Especially referring also to your technology structure and to the international global world we are living in. It means that if only one party to a case is very powerful, the chance that this, be it with money, having the best lawyers, be it with political influence, having the best friends, be it just because they have a long breath to live through a long procedure, will probably prevail, even though that doesn't mean that justice is administered. So therefore, we need to make sure that the judiciary stays really independent. And also here, I'm sorry, I disagree a little bit with my learned colleague in the speech before. I'm sorry, I'm German. We are sometimes always having to say what we think. Not English enough, maybe. Because I don't think that we should mix institutions. I think the rule of law and the defense of the rule of law, and I'm sorry if that is maybe a very European perspective, lies in especially the independence of the judiciary. It starts already, that's a personal quote now, with a question, and also in Germany we have this, that sometimes former politicians are elected to be Supreme Court judges. I don't know. Most of those colleagues are great and independent, but I think we should be very careful, because otherwise we will not be able to keep count. And as I said, I don't like it, but as I said, I'm from Germany. Also, the Nazis in the Second World War used the law, but it was rule not of laws or on rule by law. And I think we all saw what happens and see it every day in other parts of the globe as well. So from my perspective, those pillars I just mentioned are the ones that promote the order and the support of the rule of law. Education towards non-discrimination, respect of human rights, zero tolerance of corruption, abuse of power are the basis of what we have to strive for. And I can gladly report that the International Bar Association has the rule of law as one of the major goals of a strategic plan to not only reform our own organization, but to reach out and to become even more important with the bar associations around the globe. And we have also 3 pillars of this: access to justice, independence of the legal profession, and enhancing understanding and respect for the rule of law. I think we have to increase awareness of those principles. We have to lower the costs and into the roots of justice. And as I said at the beginning, we need to support the people who really don't have access to this decent justice. To develop an understanding of nature of the attacks against the legal profession around the world is very important. Bar associations are under not direct attack sometimes, but they get certain rules and regulations they have to obey to, and therefore they have also the difficulties to overcome and to probably sometimes formulate their real goals. So overall, I'm very optimistic because I think we as lawyers are exactly the ones who protect the rule of law, who can teach the rule of law, who can reach out, and I would just inspire all of you, especially the young colleagues. I learned that you all have to wear black suits in court, so that's why I see so many men and women in black. Go out there, reach out, and form exactly this. Be proud to be lawyers, show the community you live in that what it means to be a lawyer, and that the rule of law is in everybody's hands and is protecting everybody, individually and as society at large. Thank you very much.
Thank you, Dr. Benzer, for your very insightful address on the topic. And I'm sure your partially dissenting view will also give a different perspective on the issue. May I now invite Mr. Prashant Kumar, President, Bar Association of India. Mr. Prashant needs no introduction. He is very well known to, I think, the entire audience, except that, but in addition to that, he is a past president of the Law Asia, and he too wears too many feathers in his cap. If you start counting all those feathers, the session will be concluded. So over to Mr. Prashant Kumar. Please do come.
Thank you, Rachana. I have already spoken during the inauguration, so I'll try to be as brief as possible. Friends, along with the program, there is a message of the senior-most Supreme Court judge, Justice Sanjay Kishan Kaul, at the last page. And there, in the second paragraph, the last sentence, I invite your attention to. It says, "The rule of law is the accepted norm of all civilized societies that protects the sanctity of life and liberty." I think this one-line definition presents the essence of the rule of law and humanism, because ultimately everything which we encapsulate under the umbrella of rule of law leads to protection of sanctity of life and liberty. Rest all are components, how you operate them, in what manner, through what kind of governing systems, because world over there is this lot of different varieties of systems of governance, the way the affairs of the government is conducted, but essentially the goal and objective of any society, any state, which inheres in the rule of law, is protection of life and liberty. So here, I will just try to bring one more dimension. And especially, it is there at the level of the nation states or countries, but we find it more and more powerful, manifestation of it in the international or global concept. That is that lot of power in international arena is concentrated in the hands of private corporations or the multinational corporations. The United Nations, recognizing that, started a drive to, and especially with the organizations which talk about rule of law, law societies, bar associations, to talk about the business and human rights. Now there can be a narrow conception of it, that each business operating its own field has to respect human rights of the labor which works there, human rights of the community it supplies goods and services to, and if it is creating value out of natural resources or carrying manufacturing processes that create environmental damage and pollution, how to mitigate that. So all these come under the umbrella of business and human rights. But let's try to take it a step further, and we say that business or private power and the rule of law. The examples are that we faced this in 2006, 2007, even in 90s, and now we are talking about a recession, a global recession. And the genesis of global recession lies in the lending practices of the banks, the global huge banking institutions. What the banks do, the banks take money or value from people, whatever manner they are incorporated, and then they make the decisions to lend them to corporations, to others. And the globe has suffered twice, and we are looking at a third iteration of it, from a disaster, from an anticipated disaster, that the banks are going to face challenges. It is the taxpayers' money, which country, which jurisdiction is utilized to write it off. So they are a category of professionals, a few bankers, few businessmen and all, who overutilize the capital, utilize it in imprudent ways. There are other ways it is impacted, but ultimately what happens that when the global recession takes place, everybody's human rights suffer. And it is the poor countries who suffer the most. So that's why we have to now start thinking of rule of law in a broader context. That the principles and core values of rule of law should apply to all institutions, all entities, all individuals who are empowered to make decisions which impact others. Not in just one part of the globe, but maybe everywhere. How we have to construct the rules, disciplines, and a global governance order that we expect that in all these processes, the level of prudence, the balancing of individual objectives to make profit is an essential drive for human progress. We don't quarrel with that. But how to balance all these things and what has to be the level of oversight? Now, banking, fixing interest rates, LIBOR, other things, all are done by amalgamation of private players. And the power they exercise can impact every single human being on earth. But despite that, we don't have even a conversation how to control, how to regulate, how to make that power accountable. We talk about global warming, we talk about impending environmental disaster. Again, it is not just the practices which the governments adopt and others. It is also the way the international business is structured. And one of the most tragic manifestations of the failure of rule of law globally, which one can see, is in those countries in Africa and Asia, which are endowed with a wealth of natural resources, with which their generations can survive, but they live in abject poverty, want, disease, and death, and strife. So how all this plenty, because of the lack of rule of law, because of the lack of systems in which, because it is not just that those countries are incapable of governing, they don't have a culture of rule of law. Somewhere it is also that how the businesses and others permeate and influence the governance systems and the government systems that lead to implosion of the rule of law and the consequences which are so tragic for the humanity, not just in that country, but when it becomes a template in the continents. So that is why, my friends, when we say placing humanism and values and principles and these core values, we have to start thinking beyond, much beyond what we have been thinking, because the globe is coming together not just because of travel and all, but due to trade, commerce, economic integration. But that ought to take place in a manner that integration is beneficial to all, that integration respects all the rules, it in fact respects the core values of humanism. This integration is most welcome, its progression, its evolution, but we must have rules for it. We must have systems to govern it. And that is what we want, that New Delhi should become a clarion call every 2 years for us to come together, sit together and see what are the institutional gaps, what are the ideas we have to bring into play, because as men of law who know how to apply, interpret and make laws, we are very well equipped to carry out this exercise, and we will fail in our duty if we don't do that. Thank you very much.
Now our last speaker is Mr. Alexei Klishin. Mr. Klishin is member of Presidium Chairman of the Commission on Legal Framework of Modern Integration Process of the Russian Federation. Mr. Kleshin is also First Deputy Chairman of the Federal Council of Committee for Legal and Judicial Matters. Mr. Kleshin specializes in the sphere of legal regulation of foreign investments, etc. He is author of many publications in civil law, tax law, and other international public law. Mr. Kleshin is also founder member of the BRICS Legal Forum.
Yeah, thank you very much. I asked my colleague to shorten the list of my positions, but she didn't manage to do that. Thank you very much. Thank you, dear colleagues. First of all, I want to express our gratitude being invited to this convention, which is very important. Our president, the president of our Association of Lawyers of Russia, was supposed to be here, the former Prime Minister and the Minister of Justice, Mr. Stepashin, but due to some medical problems, he didn't manage to come, but he's sending his gratitude and greetings to our Indian colleagues, and particularly to Mr. Prashant Kumar, he is expressing his support and expecting, the fruitful work and results of our mutual work. I referred to previous speakers, and in a way I'm continuing the speech of the previous speaker, Mr. Kumar, regarding different understanding, different interpretations of the concept of rule of law. The lawyers are asking each other what is rule of law and answering, and the answers seldom coincide. Anyway, what is important is that a variety of cultures and civilizations is one of the key features of this modern world. And delegates from the countries of Africa, Latin America, Asia, and Europe are present here in this conference hall. Each of these countries has its own history, traditions, culture, values, way of life, and most importantly for us, its own legal system. This is why the reality of our day is the formation of the multipolar world and the legal order based on the principles of justice and multiversity, and as well as on the equitable dialogue, balance of interests, and universal rules of international law enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states. The diversity of society forms and legal systems must be acknowledged and accepted as a certainty instead of getting into disputes over one type of such systems being better or worse than the others. Our role as lawyers is not to identify problems, but to find compromises and equitable solutions for the benefit of mankind. Our common goals include protection of human rights, elimination of racial or ethnic conflicts, fight against discrimination, violence, and crime. We should promote equal access of the nationals of our countries to the public goods, such as high-quality health and education, and should also endeavor for the reliable protection of all population categories, including the most vulnerable ones. This process requires our mutual cooperation based on mutual trust, respect towards each other's interests, observance of universal rules and values established at the time of their acceptance by the global community. International organizations, in their turn, are designated to provide universal negotiation platforms based on the principles of true multiversity, as well as to protect the Charter of the United Nations and the goals enshrined in it. In real practice, we can see that one group of countries attempt to impose its legal concepts and values to other groups of countries without consideration to their historical and cultural characteristics. We can see now that the modern system of international law is undergoing a test of strength. Approaches aimed at undermining the actual foundations of international law and first and foremost state sovereignty pose a major threat to the system. Some countries, mostly Western, intensively inculcate the concept of rules-based order as an alternative to the international law. They justify it by the alleged adherence of all countries to the uniform rules and values, the substance of which is not entirely clear, yet it is obvious that the values and interests of the proponents of this concept and the rules designated to ensure the observance of these interests are interpreted as such rules-based order, being a counterbalance to the collective rules and values based on the UN Charter. An example of practical implementation of the rules-based order is a set of resolutions on the establishment of various attribution mechanisms within the executive bodies of international organizations, such resolutions being pushed through by the controllable majority in violation of the statutory instruments of these organizations and the fundamental principles of the United Nations. These attribution mechanisms are vested with quasi-investigation and quasi-prosecution powers in order to make certain states responsible for the illegal acts allegedly committed by them. We know various examples of this attribution mechanism to be established. Considering compliance with international law to be a key factor of stability in the international relations, we stand for the collective consensus-based decisions and for the international legal order that has no alternative as the order based on the UN Charter and the ensuing principles and rules of international law. Global problems cannot be solved on the basis of unipolar approach and double standards. However, we can see the attempts to solve them on such basis in the situations related to religious freedoms, where the autonomy of states and, in some cases, regions within states must prevail. As for the international law, its provisions are interpreted by some states in their own favor. The mechanism of unilateral coercive measures, so-called sanctions, is being applied in violation of the rules of international law and the provisions of the UN Charter. The purpose of these sanctions is to disrupt the national economy and force one state or another to change its policy for the benefit of the initiator of such measures. Unilateral sanctions do not only deprive the affected states of the ability to receive international humanitarian aid, but also have a very negative impact on the situation in their social spheres. The issue of damage caused by the unilateral sanctions has been discussed in the United Nations, in particular at the General Assembly, where the resolution on unilateral economic measures as a means of political and economic coercion against developing countries is adopted biannually, and the resolution on human rights and unilateral coercive measures is adopted annually. Such restrictions are incompatible with the idea of bona fide compliance with the norms of international law, including the principles of cooperation, sovereign equality, and non-interference with the internal affairs of states. Moreover, the application of unilateral coercive measures that are not based on the international law in the absence of the relevant resolution of the UN Security Council, or that are additional to the measures taken by the UN Security Council, may be contrary to the goals and objectives of the Council's resolutions and may undermine its competence as a body ensuring international peace and security. The Association of Lawyers of Russia, a public organization with more than 35 members, has its offices in all constituent territories of the Russian Federation. Representatives of all areas in the legal profession, attorneys, legal scholars, corporate and privately practicing lawyers, judges, public prosecutors, investigators, notaries, civil servants, as well as lecturers and students of law universities make up its membership. We stand ready for the honest and mutually beneficial cooperation with the international legal community in order to enhance the rule of law as the foundation of the multipolar world where the rules of international law are observed and to withstand the threats to the security of mankind. Thank you very much for your attention.
May I sort of thank each one of the panelists over here to my left and to my right for having really made very thought-provoking presentations, full of ideas, full of points and counterpoints. And I like the fact that there was this debate and discussion, because I think it's going to stimulate us for the next set of business sessions and discussions. So I thank each one of the panelists, and may I request all of you to join me in commending them in the usual manner. I think just to end, I suspect we are beyond time. Yes, we are, by almost 17 minutes. I want to also thank them for their brevity, conciseness, and very, very sharp points, because we've hauled back a little bit on the overreach in terms of time. I think I'll just leave you with a thought. I thought I might sort of summarize it, and I thought, is there some time to take questions from the floor? But I don't think that permits. We're sort of 20 minutes nearly past 1 p.m., which was the lunch break. So I'll leave you with this thought. I'm not very sure as to what rule of law exactly is in terms of philosophical definitions, but I think I have a reasonable sense that it certainly comprises, number one, fairness. It certainly comprises predictability. It certainly comprises inclusiveness, to ensure that no one is really left out. It certainly includes, in my assessment, a degree or a machinery which is accountable. So these are features which ought to be present. Please reflect on whether in each one of our systems and societies we have attained these goals, whether we continue to fall short, and whether we can improve them. And I think if you do reach the conclusion that yes, there is scope for improvement, I suspect that in each of our communities, large and diverse as they are, we need institutions. If we are dependent on individuals, I think the system has failed. And therefore, rule of law in the context of humanism will have to be delivered at the end of the day by strong and robust institutions. With that thought, I thank each one of you for attending this session, and there will be, I'm sure, lunch which is served, to be followed by the next working session, which begins at 2 p.m. So thank you all, and please join me in a round of applause. Yes, please. Thank you. Thank you very much. So thank you very much.
Start the next working session, which is on the rule of law and the inclusive global economic growth, how to bring the objective of shared prosperity at the core of a rule-based global economic order. We have as our chair Senior Advocate Mr. Jaideep Gupta. I request sir to please begin the session.
Good afternoon, everybody. I know it's a little difficult to get back to work after that lunch, but we must make a valiant attempt. I am here to chair a session on the rule of law and the inclusive global economic growth and how to bring the objective of shared prosperity at the core of a rule-based global economic order. We have 4 eminent speakers, apart from the co-chairman, who will summarize in the end. I have struggled with this topic a little bit, but ultimately it reminded me of the title to the famous book by Thomas Friedman, That the World is Flat, where he suggested that the world should be viewed as a level playing field in terms of commerce, wherein all competitive resources have an equal opportunity. In this book, he spoke about technological, historical, and geographical factors that have leveled the world as a playing field, but it is obvious to us lawyers that it also requires an international cross-border legal framework which is yet not in place because the legal framework is seen as enforceable only within the boundaries of nation states. Green shoots, however, can be seen, at least to some extent, when we look at the model laws which UNCITRAL is formulating, 2 of which have been adopted in this jurisdiction, and many other jurisdictions have also taken them on board, namely arbitration law and insolvency law. Can we look forward to the removal of jurisdictional boundaries in commercial matters in future? For this and other related issues, we have with us 4 eminent, illustrious lawyers to give us their thoughts and their vision. May I request first Mr. S.S. Naganand, Senior Advocate of India and Vice President of the Bar Association of India, to give us his thoughts. Sri Naganand, as most of you would know, is a top practitioner in our jurisdiction. After a brilliant academic career and after setting himself up as a chartered accountant as well, he chose to practice the law. He has a legal career spanning 4 decades. He is a designated senior advocate with a flourishing practice on a wide range of areas, including, of course, constitutional and commercial law. He is also the Vice President of our association, which is organizing today's function. He is an alternate counselor for India and a member of the Executive Committee of Law Asia. May I invite you, Mr. Naganand, to address us. Thank you.
Thank you, Jaideep ji. My co-speakers this afternoon, fellow delegates, and seekers of knowledge. Because if all of us were not seeking knowledge, we wouldn't be here on a Saturday afternoon trying to understand some nuances of law. The topic that is given for this afternoon session is the rule of law, the inclusive global economic growth. How to bring about the objective of shared prosperity at the core of rule-based global economic order. The topic is very long but simple. In simple words, what it means is there is plenty around, so how do we make rule of law a reality for everybody? I am tempted, before I go into the subject, to say a few words about a very ancient Indian work. Now, that ancient Indian work, today's theme of the conference is elaborated, and the shloka reads like this. It's a small Sanskrit verse, It says, it is from the Maha Upanishad, as Shyam mentioned in the morning. The shloka is like this: Ayam nijaha paroveti ganana laghu chetasam udara charitanam tu Vasudhaiva Kutumbakam. Now, to briefly explain what it means, it says, if somebody thinks this is mine, that is his, then the person who's thinking like that is very narrow-minded, whose mind is very small, he doesn't have expansive feeling. But one who thinks in a very liberal way, and he is a wise one, for him the whole world is a family. Vasudhaiva Kutumbakam. That's how the theme of the conference was thought of by Prashant and the team. So if we bear this in mind, the topic today becomes very important. And again, before I go into it, I'm again going to delve into some ancient writings in the Indian scenario. All of you might have heard of the famous Indian philosopher Adi Shankaracharya, who lived about 1200 years ago. And he wrote a very small work called Prashnottara Ratnamalika. It's a composition of only 67 verses, in which you have, each verse has 2 lines, each line has 2 questions and 2 answers. So you can imagine the precision with which he wrote it. I'll just refer to a few verses. First question, he says, Ka patyatharo? Answer is dharma. Patyatharo means what is it that everybody should do? What is good? What is ideal for everybody? Answer, he puts it in one word, dharma. Of course, dharma has many connotations. It simply means that which is fair and just for everybody. That is dharma. If you are a father, then it's your responsibility to look after your family, your children, educate them. That is the dharma of the father. Same thing for wife. So dharma is that which is good for everybody. So the answer to the first question is dharma. You follow dharma that is good for everybody. Then second one, very important. Kim sadhyam, what is it that you should achieve? Answer, he says, is bhuta hitam. That means bhuta hitam means love for everything, love for everybody, love for all living beings. I mean, just see the expansiveness of his thinking. This is what is ideal in the Indian philosophical scenario. Kim cha anartham. That means, what is it that is ideal? And the answer is yad avasare dattam. That means, when somebody is thirsty, if you give him a bottle of water, that is the best gift that you can give. But if somebody is well fed like how all of us are, and they place a beautiful array of dessert for you, you're not going to touch it at all. So that is another aspect. So you should give somebody what is necessary. And the last one I'm going to refer is ka preyasi vidheya. What is it that God will like? And that he says, karuna dineshu. Karuna is compassion. For whom? For the poor and needy. Now with this background, if you see, what is it that the Indian philosophical system is contributing towards our discussion today? If you see that, you will now realize that we are now talking of rule of law. Some of you might be wondering, what is rule of law got to do with all these philosophical thoughts? But you look at it, the key economic growth depends on many factors. If you don't have economic growth, if you don't have good roads, if you don't have good transport system, if you don't have electricity, if you don't have water, what is the rule? What is the idea of a rule of law? And that's why the Indian Constitution has expanded Article 21 to say rule of law means rule of right to life does not simply mean that you are not shot down by the government, but it means that you have to live a good life, a meaningful life, and a life full of dignity. Now for this, how do governments work for this? Now, the enforcement of rule of law means the government must give them all the rights of property, rights of individual freedom. And if you don't have economic growth, now economic growth is directly connected with the making available of the rule of law, at least in the developing world, in the emerging world also. But in the extremely developed world, this is not such an important criteria, because the economics of an individual and his family are well taken care, so he doesn't have to really worry much about it. But in a developing world, this is very important. Now, both in economics and political science, the dominant line of theoretical inquiry on the relationship between rule of law and economic growth has centered on property rights and the institutions necessary to enforce them. For example, you need a court, you need a civil court, you need a constitutional court, and you need a government which doesn't take away. Of course, in Indian context, we have the law of eminent domain, which has resulted in number of cases and the amendment of the law where government takes away somebody's property and doesn't give him or her the money, and then there's a litigation relating to whether the property can be taken, if so, how much compensation should be given. So this is a tussle. So making rule of law a reality, there is important economic factors that has to be seen. Now, if the government is weak and doesn't make available the means for enforcement of these fundamental rights, which means that the rule of law is not being maintained, then there is widespread discontent and unhappiness, apart from the fact that they are not getting the legal rights which they are entitled to. Today, the growing inequality between the developed world and the developing world is fast outpacing everything. The same thing is happening inside the developing economies also. For example, in India, the top 10 rich people, they own more than the rest 30% of the population. If you take the top 10 rich people in this world, in India, their total net worth is more than 30% of the whole Indian population. That is the deprived classes, I'm saying. So what has happened is this disparity has come. So at the grassroots level, something has to be done. Now if you go some 30 miles away from here or 50 kilometers from here, you'll find a village where there's no water supply, there's no electricity, there is no road, there is no school. And everybody says they want to come to Delhi. Now if they come to Delhi, Delhi is going to get more crowded, and then they'll say outsiders crowding Delhi. But why don't we go and provide them something? So to do this, to make rule of law effective, economic development is absolutely essential. Now, there are some factors which are not in our hands, not in the hands of the government. They are individual problems. That is lack of education, lack of economic means to education, and that places a burden on the state. We have now a Right to Education Act in India, which says free education is guaranteed to every child up to a certain age. Now, you can have a law to say that we now pass a law to say that there shall be no corruption in our land. We shall also pass a law that saying nobody will commit any offense in this country. But that law is not going to be of any use unless you have means to enforce it. So the Right to Education Act, which gives them a legal right, is causing problems. So what is it that state actors and non-state actors can do is something which made serious consideration. Now what are the answers for this? You see, we have to find some answer. How to bring the objectives of shared prosperity? How do you do it? So I just thought of 4 things. First thing is diversify the economy. Now, in recent times, those of you who are familiar with income tax, intellectual property and computer science will realize a new expression is now coined in America, and that is called Bangalore. That's the city I come from. They say a lot of jobs in America have got Bangalore, meaning that nobody is working in America on these, everybody is working from Bangalore. So the extreme progress that India has made, thanks to language of English, which the English gave us, and the economic freedom, and the education in the field of computer education, today Bangalore has become synonymous with computer field, artificial intelligence, data analytics, you name all the fields. All of that is familiar with Bangalore. So what has happened is diversify economies. In my own life, if you see 50 years ago, we did not have a computer, we didn't have a printer, we had to look up digest every other day to find a case law. But today, sitting here on my handset, I'm going to do all the research. So the system has to be changed, and that's exactly what happened. And when that happens, there must be an opportunity, a window of opportunities. Now, many international organizations are trying to address this. One is the Gulf Cooperation Council. They are trying to break dependence on oil through a planned introduction of VAT. So they want to collect money. Then inequalities. Now in 2017, the International Monetary Fund estimated that 10% of the income in advanced economies went to just 1% of the population. I gave you a little more extreme example in India. This is overall I'm saying. Rising inequality disrupts social cohesion, but threatens long-term growth and hampers progress. So that's well known. So how do you do? What do you do with it? So you must do something to sustain economic expansion and move along on global goals. Countries have to urgently raise the standard of living of most of the deprived to address the inequalities. These investments have to come from developing world, And the developing world can't come to India and say, I'm going to invest in the stock market, I'm going to make super profits which I can't make in America or anywhere else, I'm going to take the money at my whims and fancies and go away. Yes, that is one avenue, but that can't be so. In the US, in 2017, they adopted sweeping reforms which is expected to increase the GDP growth, but also contribute to a further rise in after-wage inequality. Now, America also, same dialogue is there. You're giving sops to the most rich people, but at the same time taxing higher the lower income people. That's a big issue that has happened everywhere. Now, you have to make it sustainable. The cost of achieving the universally agreed growth rate is several trillion dollars every year, and public funds are able to cover no more than 1 trillion per year. What is needed is far greater than that. So private and public sector participation seems to be essential, and there seems to be no other way. The world's financial and capital markets, they handle in excess of $300 trillion in assets. The world needs a new financial architecture. We are now seeing what happened to the Silicon Valley Bank collapse and the subsequent effects on banks everywhere, including in India. So there has to be some global order that has to be brought about. Lastly, you have to improve institutions. Regulatory bodies have to be functioning better. Government has to be more responsive. And the government here in India is talking about inclusive growth. Now, I think Prashant also mentioned it this morning. In India, in the last 15 years, 271 million people have risen above the poverty line. I mean, this is a stupendous achievement that has been made because the rule of law is meaningful to them. What is the use of rule of law if a person doesn't get a job for 2 square meals a day? This is important. Global inequality is more about disparities of opportunities. You see, a small person living in a village about 100 miles away from Delhi, what opportunity does he or she have? So they are going to be in poverty only unless you do something to get rid of that. Of course, the union budget talks of an expression which the Prime Minister is very fond of using. It's called Amrit Kal. And he says Amrit Kal is inclusive development. This seems to be the buzzword. And of course, number of projects have been taken up in India. But we have begun, we have put a first foot forward, but the journey is long, the journey is arduous, the journey is difficult. And that is, I think, the message that we had to take, that the rule of law and the inclusive global economic growth is something which can't be achieved by laws alone, by institutions which enforce the laws like the courts, but it's essential for governments to put the head together. And if you keep the objective of this sloka in mind, which is Vasudhaiva Kutumbakam, the road seems to be easy, but the people at the helm of affairs in various countries have to look at this global perspective and have to see, America especially, the amount of energy they're using as per capita as compared to other countries, the amount of water they're using, the amount of pollution they're creating. And because of their clout, they're able to, get their way around everywhere. I think that is something which the leaders have to understand, that if you have a happy and a satisfied neighbor, he or she is never going to attack you. But if you have an unequal neighbor, people in Mexico are starving of food, so they will risk their life and, cross the crocodile-infested river to come to America. Same thing, we heard heart-rending stories about young families from India and Gujarat trying to cross over on foot in Canada and dying in the bitter cold there. This is all economic. So what is the use of human rights? What is the use of Indian constitution saying you have a right to life when this is how they're losing their life? So I think the economics of it is directly connected with the growth of it. And this is what something we need to work on. Thank you. Thank you very much.
Thank you very much, Naganand-ji, for putting on the forefront diversification, equality, sustainability, and regulation in the quest for global prosperity. May I now invite Mr. Jeff Leong Pok Lim, one of the eminent top lawyers from Malaysia, senior partner and founder of the Malaysian law firm of Jeff Leong Poon and Wong, co-deputy chairman of International Professional Services Committee of the Malaysian Bar Council, a mediator and a teacher of the law as well. May we hear from you now, Mr. Leong.
Good afternoon. I bring you warm greetings from Malaysia and from the President of our Malaysian Bar Council. Today I'll be speaking in my personal capacity as a private lawyer and also a teacher of law. I'll be speaking on international law in a multilateral rules-based order, the way forward. As you know, our world is in dire straits today. Our turbulent era of COVID-19 pandemic, Ukraine war, climate change, and digital economy is in need of global governance and a set of rules along the lines of Jeremy Bentham's universal legislation. Economist Danny Roderick, dismayed at the widening rift towards decoupling and the deglobalization of United States and China, posits that the protection of national interests should not be for the express purpose of punishing the other side or weakening it in the long run. By choosing confrontation, they have handed the keys to the global economy to their national security establishments, jeopardizing peace and prosperity around the world. Warnings about the global world order abound. We are living in abnormal times. The global liberal order is in an advanced state of meltdown. And as the world rapidly shifts from a unipolar to a multipolar reality, the international system itself is exposed to profound instability. If the situation is not handled with extreme care, the potential for a major collapse is real, and we are seeing signs of that today. The question is whether our world leaders are capable of fully understanding what is happening in real time and can muster the collective action to set new rules of the road. Now, Kishore Mahbubani has proposed a global multilateral rules-based order based on reforms of the United Nations institutions. And as he put it, mankind is now living in 193 separate cabins on the same boat. There is only one problem with our global boat. We have governments taking care of each cabin. We have no strong institutions of global governance to manage our global boat as a whole. And the only organization which enjoys the universal representation of humanity and can provide such global leadership is the UN, United Nations. And in a small, shrinking, interdependent planet Earth, the United Nations has become an indispensable organization. Hence, it will grow as a sunrise organization in the 21st century. An integrated set of global law, rules, principles does not yet exist. International law and global multilateral institutions are riven with uncertainties arising from the absence of a centralized system of enforcement and the role of state consent in the formation of rules of international law. To the late Nobel Economics Laureate for 2009, Professor Oliver Williamson, who I had the opportunity to meet in person some years ago when he won the Nobel Prize. The lens of contract approach is an underused perspective. It is thus worthy of further interdisciplinary research and study in an international law and global governance context. Professor Williamson's Carnegie Triple and Commons Triple are useful interdisciplinary and contractual law, economics, and governance frameworks of analysis that illuminate and yield new insights on the vexed problem of international law and global governance. Recently, in the United Kingdom, developments in relational law contract and also writings on United Nations Charter as a relational contract also yield additional insights for global governance. What is the current state of international law? Numerous questions has been asked. What is international law? Where is it to be found? Is there a doctrine of stare decisis in international law? How are nation-states bound by international law? Are the rights and obligations of nation-states only found in the treaties that they have consented in, signed, and ratified in domestic law? does customary international law have legitimacy? Why do nation states and their people obey international law? Are treaties that were unfair and lopsided at the outset binding? Is there a right to disobey treaties that, through the passage of time and change in circumstances, became onerous and oppressive? The resultant cacophony has spawned raging debates across the fields of international law, international relations, and global governance. The triplets of international law, international relations, and diplomacy are intertwined and conjoined. Professor Oliver Williamson, in his Nobel Economic Prize-winning work on law, economics, and governance, talk about Carnegie triple. By Carnegie triple, he meant being interdisciplinary, taking the core of your discipline seriously, and working at it on its own terms. By being interdisciplinary means to appeal to the contiguous social sciences. If and as the phenomena under study cross-disciplinary lines, you need to take a more proactive step. For example, if we reach the boundaries of law and finance, and we see that across the fence of law, the problem is actually something that you already identified. We must be bold enough to jump over the disciplinary fences to try and solve the problem on our own, or at least bring in the experts to resolve the problem. So this is the idea of being interdisciplinary in our approach to solving global problems. And having an active mind entails asking the question, what is going on here, rather than pronouncing, this is the law here. And I think, to my mind, the most important contribution of Professor Oliver Williamson was his Commons triple. And he said that the economist John R. Commons formulated the problem of economic organization as follows. The ultimate unit of activity must contain in itself three principles of conflict, mutuality, and order. This unit is a transaction. So in other words, the ultimate unit of all human activities, including international law, international relations, and global governance, is a transaction or contract within the three principles of mutual dependency, conflict, and order. The need for order or governance is thus explained. Governance is the means by which to infuse order and thereby to mitigate conflict and realize mutual gain. I will just take a short explanation using the slides of these two competing economic theories. Game theory, the strategy of conflict and mutually assured destruction, something that we have been very familiar since the Cold War and also since the return of the new Cold War in recent years. So is there a better way? The better way I propose is Oliver Williamson's Commons triple, strategy of cooperation and mutually assured prosperity. Now, Thomas Schelling won his economic prize. He wrote his book on strategy of conflict using game theory. He applied game theory to the Cold War. And basically, he says that uncertain retaliation is more credible and more efficient than certain retaliation. So this is what he said about the two superpowers in the old Cold War, where the theory of brinksmanship was applied to nuclear arms race to achieve mutual deterrence and stalemate. We still see the return of this thinking in the present day. So the idea of mutual deterrence and stalemate. So his reorientation of game theory is like this. You are standing at the edge of a cliff, chained to the ankle to somebody else. You will be released and one of you will get a large prize as soon as the other gives in. How do you persuade the other guy to give in when the only method at your disposal, threatening to push him off the cliff, would doom both of you? I think the answer is, according to him, you start dancing closer and closer to the edge. That way you don't have to convince him that you would do something totally irrational, plunge him and yourself off the cliff. You just have to convince him that you are prepared to take a higher risk than he is of accidentally falling off the cliff. If you can do that, you win. So we see the echoes of this in the present day, in the Ukraine war and the things that's happening today. And if you look at it, Thomas Schelling's strategy of conflict suited particularly the military-industrial congressional complex. The more you foment war, the more the parties will fight and dispute, and the more they will buy weapons. So this is the unfortunate situation of of game theory approach to strategy of conflict. Now, on the other hand, this is the one that I want to propose for this afternoon's working session, Common Stripper, the strategy of cooperation and mutually assured prosperity. Ultimate unit of activity contains 3 principles of conflict, mutuality, and order. This is a transaction. Governance of contractual relations is the means by which to infuse order and thereby relieve conflict and realize mutual gain. Llewellyn, also another economist, postulate that contract as a framework as opposed to legal rules in tradition, in contract. And Galanter also in legal realism says that most disputes, including many that under current rules could be brought to a court, are resolved through self-avoidance, self-help, and the like. And in many instances, participants can devise more satisfactory solutions to their disputes than can professionals constrain to apply general rules on the basis of limited knowledge of the dispute. What this is saying is that when parties are in dispute, lawyers, judges, mediators, arbitrators are all third parties, limited knowledge of what went wrong, what was agreed beforehand. The best people to resolve the disputes are the parties themselves. All right? So with that in view, it should encourage us to take a very different view to how to resolve confrontation and conflict. Now, once again, in all international relations between parties, between companies, between countries, even social contract, it is a transaction. There's mutual dependency. Parties, companies depend on each other to work together to generate benefits. And because of conflict of interest, if you want to have 100% of the benefits to yourself, nobody will cooperate with you or work with you. So they tend to share the fruits of cooperation. And this sharing, for the lawyers involved in this sort of transactions, lawyers need to play the role of statesmen rather than mercenaries acting for one side. So, and to make this work is a concept of order. Order can refer to private and public ordering. Now, the way forward, because of recent developments of, for example, in the United Kingdom, recognizing relational contracts, long-term contracts are likely to be described as relational contracts which, in the absence of any provisions to the contrary, may imply a duty of good faith between the parties. This concept of duty of good faith in contractual relations is also present in the United States and also in civil law countries like France and Germany. Relational contract analysis has been applied to the public order sphere of international treaties, where Gerard Wessel forms the opinion that courts should take into account the nature of states' relationship by using relational contract theory when interpreting a treaty in order to better reflect the true intent of the parties. The relational contract theory, and specifically its focus on overall relationship between the contracting parties, can be and has been selectively applied to make tribunals better able to accurately resolve conflicts in a way which promotes cooperation. I'm mindful of the limit of time, except to point to what Ronald Coase have also said, that due to the impossibility of forecasting needs far into the future, long-term contracts are of necessity incomplete. This incompleteness of long-term contracts implies that they require periodic monitoring and direction, and such contracts are relational in nature. The other important findings that you can perhaps discover in recent years is Professor Jeffrey Sachs' comment on John Nash's game theory. He said that because John Nash suffered from a non-communicative Asperger syndrome, he's not able to communicate well. So in his calculations and in his understanding of game theory and resolving of conflicts, he doesn't understand the need to communicate. And this is what Jeffrey Sachs said, Professor Jeffrey Sachs said, because human cooperation, and I should say human communication, allows us to mutually understand the advantages of cooperation. And of course, because we are generally in an environment of repeated or so-called iterated place, where we honor our commitments because we want to be able to continue to cooperate in the future. The potential for ongoing cooperation is much greater than the naive prisoner's dilemma framework. Hence, communication, the language of diplomacy, is the key to conflict mitigation and mutual cooperation. So, reinterpreted in the realm of international law, international relations, and diplomacy, Professor Oliver Williamson's order, both public and private, in a common triple, firstly refer to the core subject of international public ordering, that is, the international charters, treaties, statutes, and other global or regional multilateral legal instruments and customary international law. And secondly, to private ordering, contracts, agreements entered into by or between state actors and state and private actors. For example, countries may have bilateral investment treaties. They can also have more specific investment agreements as another way of ordering their foreign direct investments in another country. So international law represented by public ordering can be supplemented by private ordering to regulate international relations and global governance. And contractual governance underpinned by the common triple is therefore the means by which global, multilateral, and state actors infuse order and thereby mitigate conflicts among state actors, and where relevant, state and private actors and cooperate and realize mutual gain. I would like to just maybe share a few of the more commonly discussions that you see in the world together in the field of international relations. For example, Kevin Rudd talks about a system of guardrails and joint framework for his 3 pillars of managed strategic competition. This is actually an expression of the common triple. By acknowledging mutual dependency in dealing with existential threats, managing conflict by frequent communication and documenting security red lines and strategic concerns via public and private ordering to safely manage the competition for strategic and economic influence, bilaterally, multilaterally, and across the various regions in the world. This is how competing nations can work together. Another manifestation of this is Kishore Mahbubani's 3 pillars of peace: freeze, talk, and trade. These are also expressions of Williamson's common triple: freezing conflict in favor of diplomacy, communication, cooperation, and mutual benefit. Another famous professor of the Lee Kuan Yew School of Governance in Singapore, Professor Danny Quah, adopted the lens of approach to the problem of supply and demand in the world international order and the demand side reasons that will change the world. And he described how small countries have agency in choosing the emerging rules-based order. And because of this, their ability to choose, it still begs the question of how do you document that choice? And this talks about the importance of contractual governance and international law in executing the preferred choice of global governance. I would like to conclude by saying this. Current conceptions of international law, especially the Western rules-based international order, suffers from a Western bias threatening recolonization of the Third World. And this is the writings of Professor B.S. Chimney. In a world where only 12% of its population live in the West, it smacks of cultural arrogance and a colonial mentality to the remaining non-Western 88% of the world's population. International law and global governance built upon contractual governance theories based on consent will find greater acceptance, consensus, and legitimacy around the world. And in the present-day discussion about global civilizations working together, contractual governance would also accommodate the common and shared values of humanity that great civilizations like India, of course Europe, and of course China and Southeast Asia. And in Malaysia, I am reminded that the old Malacca Sultanate used to have their own laws before the Portuguese came to Malacca. We used to have our own laws of Malacca and maritime laws of Malacca. So civilizations are able to sit down, talk to each other, and in the process of negotiation, recognizing what is common, what is shared, and the rest is up to the negotiations, and they can then come together to decide what is the treaties, what is the amendments to the UN reforms that we need, and through this process of negotiation, come up with rules that are acceptable to all, and they will then follow because they have consented to it. And in the reforms to come, I think this process will have to continue, because if you understand what Ronald Coase is saying, the problem of relational contract, things change. The world change over time. So parties will have to will sit together. If they can, they'll have agreements and they will say choose arbitration, choose the World Court to make certain decisions. This is what Professor Williamson referred to as exogenous governance, referring to an agreed third party to resolve the conflict. But if you cannot agree to a third party to resolve the conflict within the commons triple itself, mutuality, mutual dependency, conflict, and order is a dynamic interchange of circumstances where parties are able to sit down, communicate, talk about problems, resolve, move forward. And if the situation changes again, they will repeat that process. And the reputation of honoring this sort of commitments, it is important to convince the rest of the parties in countries around the world to accept that this is a party that will honor the commitment. I'll stop here and thank you for your attention. Thank you.
Thank you, Mr. Long, for suggesting Oliver Williamson's theory of the common triple and the unit of a transaction as the basis on which we can move forward. I would now like to request Mr. Upul Jayasuriya from Sri Lanka to address this gathering. I have been aware of Mr. Jayasuriya's work from 2013. He has been an untiring campaigner for the rule of law, and he has himself stood up against injustice and loss of democratic values and the loss of the dignity of the profession, sometimes at a risk to himself. He was awarded in 2015 the Rule of Law Award of the Commonwealth Lawyers Association at Glasgow. He is a former president of the Bar Association of Sri Lanka, and I can summarize his commitment simply by mentioning that he is presently appearing in a landmark case in Sri Lanka to bring to book the members, and I mean all the members, the senior most of them, of the former government for economic crimes. Over to you, Mr. Jayasuriya.
Thank you for introduction, and I think I should say one sentence about the Rule of Law Award that also entailed a award of US $5,000, which I donated back again to the to the wife of a slain journalist. Because those are the people that we fought for, not for us. So in this topic, I'll straight away get on to the topic. Before everything, I must thank Mr. Prashant Kumar, my dear colleague, whom I have been associated with for more than 10 years, and also most of the other people on the head table, and also the others in this gathering. Talking about rule of law, and I heard the interpretation quoting from the Western world by Vikramjit Banerjee in the morning, saying that that was a recently concocted theory of the Western world, the rule of law, which I beg to disagree with his opinion that he expressed. I think the rule of law is much older than that, centuries, more than, I think, 260 centuries. That was the time of, I would like to quote just one example, Mahinda Arahat, the great son of your great Emperor Ashok, who brought Buddhism to Sri Lanka. When he came there, he saw the king going deer hunting. He wanted to examine the knowledge and the intelligence of the king. And then he asked a few questions, and also he gave him a little bit of advice. He said, "King, you are going on deer hunting. Make no mistake that these deer, the animals, and the plant, fauna and flora, and all the living creatures do not belong to you. You are only the caretaker of it. You can't kill anyone at your will. You can't destroy the fauna and flora at your will. You can't affect the living beings at your will." That was a word of wisdom that was given. So I think this emanates from far beyond the Western world. But Western world interpretation, of course, is something that have been now inculcated, and then is something that rule of law, as we all know, is a ultimate bedrock of the principles of democracy. So the principles of democracy and the rule of law that they think is something that applies to all the other countries except themselves. Except themselves. If it is otherwise, the interpretation could be otherwise, I think the African nations will not be poor as they are today. All the wealth, national wealth, has been now taken away by various other countries where the rule of law. In the new economic order that we are all seeking to, we are all in search of, is nowhere to be found in those countries, possibly with some corrupt rulers who pledge, who sell what is due to those poor people in their health care, in their basic needs, food, clothing, and lodging. That is what is yet to be found. So it is the entire world. I think this is a good start that we have keeping a leap forward in the Delhi Convention. We can formulate it and then identify and then lay the guidelines and the rules as we go along. Because there are so many countries, when we talk about the money laundering, let's say, money laundering situation. There are so many countries, it's not necessarily money laundering is on drug money or even money that have been plundered without paying taxes of the respective country of the country of origin. There are so many companies that, in fact, when I was having a discussion with one of our colleagues here in this gathering, he was telling me that there are so many companies of Sri Lankan companies that have created shadow companies in India. And they are doing a shadow transaction, depriving the country of the import revenue of US dollars that has to come to the country. So that is how one of the problems that we are going through now with the shortage of dollars. I'm thankful to India and also China and Japan, who I think yesterday decided to restructure the dollar loans that have been given to Sri Lanka. A new economic order has been now created. The president of the country, he has done a lot with regard to bringing back the new economic order. Some of my Indian colleagues asked me the question, is it now safe to travel to Sri Lanka? I would only give the answer with one sentence, that is to say, year on year, the month of March 2023, we had the highest number of inflow of tourists comparatively with the previous year. So that explains that we are a safer country and you all can visit to Sri Lanka without any inhibition. No queues, no shortages or anything, everything is available. And the peaceful country that we had once upon a time is back again. And we have the best of hotels and the warm climate to offer at any point of time. Now with the global vision that is now emerging with India, China and Japan getting together with a common currency, I think that has sent some shock waves to some of the countries in the Western world, and they are watching very closely as to what would happen. I think this new alliance is also being supported by some of the Middle Eastern countries, which is a welcome thing that had to happen. At some point of time, we have to ensure that it happens. So what I was explaining earlier with these shadow companies that has been incorporated in different countries, we have to come to a treaty. Let's start it from Asian countries. Let's start it from the countries that we can talk to, where when complaints are made by governments, not necessarily whether those people have been prosecuted in the respective country or not. When such complaints are being made, such information, whatever is available, even in the banks, there were certain instances where one of our ex-rulers was said to be, he had this entire family of more than five brothers in the cabinet of minister. He's supposed to be having billions of dollars in a Dubai bank. When the investigations were launched to examine how much money he had, they were only insisting that you had not prosecuted them in your country. To prosecute them in our country, we needed the information. That was a catch-22 situation. As a result of that, they did not give the information that we sought. So finally, they went scot-free, and the people thought that the allegations that were brought against such people were just baseless, which was not the case. Because they had billions of money. They have assets that are not accounted for, that cannot be accounted for. So this is something that we need, and this could be a foundation stone, the Delhi Convention. We can move forward with the hope that these countries can get together and to nab these violators and establish the new principles of rule of law, to catch the rogues, to get their assets back to their countries where it deserves to be there. Because these are not assets that belong to them. On paper, though it belongs to them, it belongs to the people of those countries. Now, though we are a small dot on the map, India and Sri Lanka, we enjoy the democracies, I think in this region, the oldest democracy. We are proud of it. We have acted on that. Many professions have stood up from time to time, including the legal profession. That has been at the crest of the wave at the necessary period of time, including what we call the Aragalaya, the struggle time, the not so tranquil times in Sri Lanka. The lawyers, more than 5,000 lawyers in Colombo. 5,000 in Sri Lanka is a huge number, though it is not so in Sri Lanka and your territory. Because I heard that the Supreme Court BarAssociation of India alone has about 30,000 members. But here, more than 5,000 lawyers, senior and junior, some were even law students. They joined the march, and then they were there on the day that the president took to his heels and then ran out of the country. So, we are a country that we have been appointing ministers to the cabinet of ministers on the friendships and the connections, and also to scratch my back and your back. But here you can be proud of a country that in India, you have the best of qualified people who have been appointed as a Minister of Finance, and also the recent change of the cabinet reshuffle. I found that larger number of younger people have been brought into the cabinet with professional experience and competence. This is what we require in our country, but that does not mean for a moment that the oppressive and autocratic laws that have been brought, jeopardizing the personal liberties of the individuals, cannot be tolerated at any cost in any jurisdiction, be it in India or in Sri Lanka. One of the examples that we are giving at this moment of time in Sri Lanka is the Anti-Terrorism Act, which is now brought in for the purpose of doing away or substituting it with this Anti-Terrorism Act, taking away the Prevention of Terrorism Act, which has more autocratic provisions. So therefore we are fighting on that. The lawyers, I think one of your Chief Justices, Chief Justice Altamas Kabir, said this from the bench in Sri Lanka. He said the lawyers have a huge responsibility in ensuring the rule of law, and also to take the flag forward for the people of a country in ensuring that justice is meted out to them. That's the principles of rule of law has to be administered equally and to all of them who cannot afford to seek legal advice and then retain them. I think there are a large number of young lawyers here. There are a large number of law students who would be one day lawyers, and I'm sure you'll be lucky to carry a brief from a client who needs more wishes than you when you are carrying the brief for the first time in your life. But that's the time that you should really focus on these issues. You are the pallbearers of the future India. You are the pallbearers of future of this country, and also you can send a message to the entire world with what you do in the future to come. Now, when we are talking about rule of law, is it an enforceable thing? In Sri Lanka, we have this incorporated in Article 12(1) of the Constitution, which says all persons are equal before law. all persons are equal before law. So we have been using this provision to challenge every kind of untowardly thing, maybe be it a tender, be it the legal process that's going on, be it the mishandling of the economy. That's the case that I said, it was referred to that I have for this case. This is a case where the monetary law, I say, is the second most important law next to the constitution. Because the monetary board can either make it or break it. If they violate the law, not for the love of the country, if they violate the law for the love of their job, without having to displease the rulers who appoint them there, they have greater responsibility to the people. And that is what they shirked in their responsibility. That is why we have filed action against the respective governors of the central bank, including the members of the monetary board, and the ministers of finance, and the entire cabinet, and the president. And I'm glad to say, I'm proud to say, that the Supreme Court of Sri Lanka, divisional bench of 5 judges, have granted the leave to proceed as the requirement stands, and they have also made a interim order on the Auditor General of the country to examine and report how much we have lost by virtue of 3 areas. One is the pegging of the dollar at 203 rupees. Secondly, the payment of US dollars, $500 million, which was the last ISB that was settled. And thirdly, the delay in going to the IMF. Now the Auditor General has given this report, a 500-page report, which I am possessed with. I am studying it. And it has identified that the regime that came to power in 2019 December, within 1 week of his coming to power, President Gotabaya Rajapaksa, within 1 week, without asking, with no business chamber, no group of people asked for this tax relief, he unilaterally gave a tax relief without any analysis, and that cost the coffers of the government 473 billion rupees in the first year, and in the second year 520 billion. And the third year also equal number should be over 500 billion. So this is what resulted in the country's economy going down and finding it difficult to get on with the day-to-day expenses that we had to proceed with. Now, when I say this, you might even being inquisitive lawyers, you might find out as to, you may want to ask the question, how does this come under the rule of law, or Article 12.1? When the legal provision is there, on the statute book, very clearly setting out that it is the responsibility of the central bank to fix the currency rate, and such decision cannot be interfered. The integrity of the monetary board is maintained. It cannot be interfered by anybody. And if there is anyone to talk about that such matter, such decision, it is only the Minister of Finance. Minister of Finance is the only person who can talk to them in order to come to a understanding, and then make them agree if he differs in opinion on what the central bank has so decided. That did not happen. The secretary to the president was writing letters and saying, you are not going to change this rupee devaluation. So the governor of the central bank, who loved the job more than the country, he took the advice of the president's secretary's advice that was given to him in writing, which is there before court, and did not change the dollar. As a result of which, we lost all the revenues that were going to come to the country from all our expat employees. And that was in the region of about $7.5 billion for a year. It went down to nearly $3 billion. We lost about $4.5 billion in that alone. So as a result of that, we had to curtail all our imports, including drugs and the most essential items for the hospitals. So now it has come back to normalcy, and then we are somehow before even the IMF first tranche came into the country, we have managed to save the situation, and we are happy that we have been able to do that. Talking about oppressive laws that are brought in by different regimes in different countries, be it in my country or in your country, one must remember one thing, that is, those people who blindly raise their hand in support of such laws, I think it is happening in Sri Lanka, in India also. Some of the laws, particularly money laundering laws, I am told, have been brought in not by the current regime but the previous one. They never realized that these very laws will be used against them. They never thought that these very laws, they will be the subject of misuse of such laws. So they open the gates for somebody to misuse the law, and now they are having to face the brunt of it. So they are the very people who will have to safeguard themselves in the future to come. I would like to quote from Edmund Burke, who said that it is the triumph of the evil is for good men to do nothing. The lawyers have to be on the wave of the crest of the wave of this good governance, and it is you who has to take the baton and the flag in front of the brigade of the people to make sure that they get what they are entitled to get. But in doing that, we need an independent judiciary. I'm happy that there is an independent judiciary. Well, quoting from an eminent lawyer who is no more from Sri Lanka, Dr. Collina de Silva, he said, there has been bad judges and there will be bad judges, but there are no bad judges. So he did not want to upset the judges who are sitting on the pedestal. Pandit Jawaharlal Nehru said that when judges have been appointed, they must not only be first-rated, they must be considered to be first-rated, and then only they are qualified to be appointed to such onerous office. Let me conclude with a quotation from Rabindranath Tagore. Give me the strength lightly to bear my joys and sorrows. Give me the strength to make my joy fruitful in service. Give me the strength to never disown the poor or bend my knees before the insolent might. Give me the strength to raise my mind above daily trifles. And give me the strength to surrender thy will with love. Thank you.
Thank you, Mr. Jayasuriya, for demonstrating the practical aspects of fighting for the rule of law and the use of the equality clause in the Constitution to attack economic crime, and for bringing home to us the importance of the lawyer in the process. And may I say that we are very happy to learn that your beautiful country is again safe for us to travel in. May I now request Ms. Araceli Flores Bueso of the Honduran Bar Association to address this gathering. A lawyer and a teacher and a member of the board of directors of the Bar Association of Honduras, a counselor of the National System of Human Rights Protection, a founder and member of the Political Commission of Liberty and Refundation Party, a precursor of the law of parity and alternation, defender of women's rights, vice president of the Trade Union Front, Bar Association of Honduras, and a founder of the National Front of Popular Resistance after the coup of 2009. I don't think we can get a CV better than that to talk to us about the rule of law.
Good afternoon. Good afternoon. Estamos un poco cansados después del almuerzo. Me voy a auxiliar de mi hija en vista de que hablo really speak English.
Good afternoon. We're a little bit tired after lunch. I will get the help from my daughter, me, because I speak a little English.
Me complace compartir este espacio con los compañeros abogados de Sri Lanka y los compañeros del Colegio de Abogados de acá de la India.
I am pleasure to be here sharing this time with you, with the people from Sri Lanka, the persons and all the Bar Association of India, and all of you.
Mi país tiene 8 millones de habitantes y somos 25,000 abogados y abogadas en todo el país.
In my country, Honduras, we have the population of 8 million, and in all of the country, we have 25,000 advocates in all the country.
Tenemos que hablar sobre economías globales. Y bueno, estaba leyendo unos datos del Banco Mundial.
So we need to speak about the global economy, and I was searching for some data of this theme.
Se cree que la economía mundial crecerá 1.7 en el año 2023.
So it is believed that economy will be projected to grow 1.7%.
Y 2.7 en el año 2024. La fuerte aceleración del crecimiento será generalizada.
Okay, so it will be projected to grow 1.7 in this year, 2023, and 2.7% in 2024. So it will be a sharp slowdown, and the growth will be widespread.
Y los pronósticos se corregirán a la baja para el 95% de las economías avanzadas, como los países como la India.
So the forecast will be corrected downward for 95% of advanced economies, and for almost 70% of emerging markets. This is the source of the World Bank.
Y un 70% en los mercados emergentes.
And 70% of emerging markets.
Bueno, yo quiero hablar un poco de lo importante que es mencionar el principio fundamental que debe prevalecer en las economías globales, que es la solidaridad.
So I want to speak a little bit the importance to mention the fundamental principle that must prevail in the global economy must be solidarity between nations.
Entre las naciones que tienen mucho y las naciones que tienen poco.
So this solidarity must be between the nations that have a lot and nations that have a little bit less.
Como abogados y abogadas, conocedores de las leyes, nuestro compromiso debe ser procurar hacer prevalecer la justicia social.
So we as lawyers and professionals of the law, our commitment must be to ensure that justice prevails in each of our acts.
El Estado de Derecho se refleja por la legalidad y el cumplimiento de las leyes.
So the rule of law is reflected by the legality and compliance with the laws.
Respetando también todas las libertades individuales que tenemos en cada uno de nuestros países.
Respecting individual liberties that we have in all of our countries.
En mi país me siento muy orgullosa de formar parte del Colegio de Abogados y haber restablecido y apoyado el Estado de Derecho después de salir de un golpe de Estado que tuvimos en el año 2009.
So in my country, I feel proud to have worked in the part of the restoration of the rule of law in my country, Honduras, where we worked to bring the first woman president in the entire history of Honduras, Xiomara Castro. And that was after 12 years of living in a state of drug dictatorship government.
Power woman.
Women power.
También estamos orgullosos de formar parte de ese equipo que está haciendo los cambios y estamos fortaleciendo ese Estado de Derecho que en cada una de las naciones debemos tratar de prevalecer.
So also I am really proud to be working side by side with our president to ensure this rule of the law in our country and have different conditions for everyone.
Bueno, ya hemos hablado bastante y veo que estamos un poco cansados. En conclusión, hablar sobre economías globales es hablar de establecer estrategias, establecer lazos de amistad, establecer alianzas para apoyarnos entre naciones y entre gremios.
So I think we've all speak a lot and we're a little bit tired, but just in conclusion, I am really happy that all of our countries are working towards the principles of the rule of the law, and we can get stronger together, we can work together, so we can have better conditions, better rule of the law in every country, and also we can also help the global economy.
Y bueno, es un placer haber compartido con todos ustedes. Espero que puedan llegar a nuestro país, serán todos muy bienvenidos y me ha encantado estar en su país y compartir con todos ustedes. Muchas gracias. Namaste.
So it is really an honor to be with all of you. We had to travel for 3 days from the other side of the world to be here with you. It is a pleasure. You're all welcome to Honduras whenever you want. You can try our food also. It's not so spicy as yours, but it's really good. And thank you for all your attention. We're loving your country.
Namaste.
Namaste.
Thank you so much for telling us about the situation in Honduras and for telling it to us in your beautiful language. Thank you so much. I would now request Dr. Ramaswamy, a Vice President of the Bar Association of India, to give his closing remarks and the vote of thanks.
Thank you, thank you, Chair. Yeah, it's been wonderful to listen to those eminent speakers, lawyers, specialists, experts. In fact, Mr. Naganandji has started with the opening statement that there are plenty, but rule of law to be for everyone. That's the crux of the entire story of this topic. When there is a plenty, there must be equity and equal distribution. As I come from economics background, as well as a legal background, I would really appreciate the way he opened the topic. Where there is no equity, and even there is a plenty, inequality can create depression, deprivation, inflation, stagflation. That can have a great disharmony, conflict in the society. That's what the opening statement, which is a comprehensive outlook of the topic. I'll come back to Mr. Naganandji after a few minutes. Then Mr. Jeff talked about the importance of international law international treaties for the economic growth and economic development. Indeed, it is essential. He also talked about the importance of interdisciplinary approach. In India, we emphasize on the interdisciplinary approach. He also talked about the importance of reform to bring change. Indeed, essential. When there is no reform, there is no dynamism. So reform is nothing but a dynamic change in economic order. Upal talked about disperse the views of Western concept of rule of law and brought 2000-year-old, trace the history of ruler of Ashoka and emphasize the importance of rule of law. Indeed, it is important to note. He gave the crux of the Sri Lankan crisis corrupt story, and then he gave a prompt confidence that how this country is progressing, economic order. Flores talks about the importance of rule of law for better economic development, and also she talked about the women empowerment, promoting better economic order. However, India is a classic example for this topic, where I would like to, I said I'll come back to Mr. Anandji. He opened the first ball with 6, but ended with little, a kind of craxy. He said, government must give all rights, and there must be diversification of economy, correct? But very disturbing word that he ended, I don't know why, because he started arousing start. Journey is difficult. Trust me, journey is beautiful in India. If you go by the new economic system, with the new education policy, and if you look at the last 2-3 years budget, the development of economic system of focusing on inclusive growth, indeed, India is a role model. Even for the women, for the children, including rule of law. Look at the way that we worked for the rule of law, for the women's development, children's development. Take example of JJ Act. JJ Act, India is one of the classic examples of world to admire about India's JJ Act. Protection of children in conflict with the law, protection of children with care and welfare. So India is a classic example to promote economic order in terms of looking at the inclusive growth for the marginalized sections, for the women, for the children, for the physically challenged. In terms of bringing harmony to regional parity, leaving away the disparity. India is again the classic example in terms of, if you look at the economic aspects. There are few important areas I like to pinpoint in a very short while that India is a world-class example of addressing the constraint of the excluded and marginalized sections in rule of law and economic development. India is the first country in the world. India is the first country in the world, as Narendra rightly said, to looking at the diversification of economy, different sectors of economy for the different section of society. The World Bank gives in the latest report, among all developing countries, including semi-developed countries, we don't want to call third world countries, India is one of the finest countries looking at non-discriminatory factor and working on high potential of poverty reduction. That is where I would like to pinpoint that inclusive growth in India is a world-class example, including housing, poverty, alleviation, housing, health sector, education system. Only one point I would like to pinpoint for the inclusive growth for right to education. Nananji rightly emphasized. The new education policy provides 1 billion skilled individual human resources for the world. The world is going to depend upon India's human resource. India is ruling, India would rule in terms of human resources, skill development. Thereby, new education policy sharpens the skill development through which we are making resources available to the world. That is how India's the best part of looking at the inclusive growth for prosperity and economic development. With that, I conclude. I appreciate the eminent speakers, their own case studies, and it is extremely important for us to learn. Thank you. Jai Hind.
May I request everyone to now join for tea? Yep. And we'll be back in 10 minutes, if possible, for the next session.
You also covered it. Thank you for the chairman.
एक चाहिए ये चीज़ बताओ इसका माइक बंद कर अगर मुझे वीडियो प्ले करनी है तो मैं इसमें भेजूँ कैसे प्ले करनी है वो डाल देगा इसमें अब यार ये बंदा नहीं
Good afternoon to you. It's a second challenging session post-lunch, because the first session is always very challenging. The second session is not so challenging. But nevertheless, I can assure you, though we are running nearly 25 minutes behind schedule, and we also have to prepare you for some great entertainment after the next session. So we'll try to wrap up as soon as possible. I'll make a few remarks, and then my co-chair Yakesh will introduce the speakers, and each of us will they will say something and speak. After that, subject to the clock ticking, we may have a few minutes for some questions, if that is possible. But before I make that, I think some opening remarks. All of us are aware that the domestic arbitration scenario in our respective countries, how they work. And there is no problem with domestic arbitration because they're usually done in accordance with the regulations in each state, each country, and they're fairly well settled, though in India, the law of arbitration has been settled, unsettled, settled, unsettled, and we're in the same situation now. And I must tell you one unique thing. The largest number of decisions of the Supreme Court on any new legislation that has come in India is under the Arbitration and Conciliation Act of 1996. So it tells you what is the vibrancy of the litigation scenario that is there so far as arbitration is concerned in India. Of course, I'm not going to talk about that. But the session is trying to focus on international commercial dispute resolutions. Now, what exactly is the issues relating to that? And those of us who have been in this practice of international commercial arbitrations are familiar with the jurisdictions of SIAC, Singapore International Arbitration Center, the Paris Court, the Geneva, London and New York. Now, these seem to be, and Hong Kong of course, seem to be the preferred arbitral destinations. Because I remember many years ago in negotiating a contract with a Canadian financing company, the topic arose about arbitral clause, and when I was advising the Indian company and said, you know, we must put our foot down and say nothing doing, we don't want international arbitration, we want it arbitration in India. The lady who was advising them was a law officer and she pulled me aside and said, sir, I think this will be a deal breaker. If you want the financial assistance and under this contract I have strict instructions, we are never ever going to agree to a arbitration in a member country where we are funding. It has to be international. Then I said, all right, we have no choice, so we go ahead. Now, how is this litigation scenario changed over the years is something which we must look at. Today, international trade and commerce has gone up by leaps and bounds. And we have the Hague Convention and the United Nations Charter, of course the UNCITRAL. Now litigation, domestic and litigation international are fundamentally different. The reason is that the laws which govern these litigations, there are two laws. One is the substantive law and the other one is the procedural law. So you can have an agreement on substantive law, and if you have an agreement on substantive law and you have an arbitration in London and you provide that the Indian law will apply, then the Indian law has to be applied by the UK tribunal. The converse of it sometimes, anti-suit injunctions are gone, we take them to court in India, when the main argument is that, well, this is an arbitration which has to be held in Geneva and the applicable law is India. So how the hell is Geneva court going to decide the Indian law is an argument which is addressed. But of course, that is well settled by principle that any foreign court can also look into Indian law. But I must tell you some aberrations. Recently, Supreme Court of India had occasion to deal with one such case, where a 3-member arbitral tribunal sitting in Singapore made a huge award in favor of one of the government companies. And there were 2 judges of Indian origin who were both Supreme Court judges. And the argument that was addressed was that Indian law had to be applied, but they did not apply the Indian law relating to damages and awarded a huge sum. Of course, that was challenged. It went to US courts, then it went to Indian courts. And then finally it landed up in the Indian Supreme Court, which recently held that the arbitral tribunal award is unsustainable for more than one reason, and they set aside that. Of course, the challenge is still available elsewhere. Now, the complexities are the procedural law in different countries are different. So, which is the procedural law or the curial law as we call it, which will apply, and to what extent? For example, one arbitration that I did in Singapore, it was SIAC arbitration, seat of the arbitration was Singapore, applicable law was Indian. The tribunal decided something, one of the parties challenged it in the Singapore court, and they had to apply the Singapore curial law for that purpose, and now it has come to the Indian courts again. So it is important for us to see how exactly are these international jurisdictions going to be enforced. Another important ticklish issue which arises very often is the enforceability. Of course, there are covenants, there are laws also for enforcement of foreign awards in India. The Arbitration Act also provides for it. But invariably, there are challenges relating to that. And these challenges are something which bogs down the result of the case in Indian courts. Now, arbitration is of course an agreement between the parties. One other issue which has troubled courts in recent times in India is that if arbitration agreement is between A and B has entered into an agreement with C, and C has derived some benefits from this agreement under A and B, can C also be roped into arbitration? Because the agreement is only between A and B. And this issue has troubled the Supreme Court. There are two decisions which say that C can also be roped into, one decision which says C cannot be roped into. Now the matter is before a larger bench. Why I am giving this example is similar issues are going to arise in different jurisdictions. This is the overall scenario that I am mentioning. But the object of this session, as I see it, is how do you deflect this arbitral procedures insofar as BRICS and other countries away from these arbitration market. I am using the word market because you all know that this is a very, very vibrant market, and in India the law of champerty is still in operation, so no one can fund a dispute and expect to share the profits of that dispute ultimately. That's illegal in India. But it is now well known that international treaty arbitrations, this is the way things work. There are big corporations, financiers who fund millions and millions of dollars into litigation, and they take 30, 40, 50% of the spoils whenever it's an international treaty arbitration. This is illegal in India. Now, what should be the framework? What should be the procedure insofar as deflecting this away from the traditional centers of international commercial arbitration? I think that is what we are talking about. I can conclude by only referring to a small meeting we had in the BRICS Legal Forum, where in Rio de Janeiro about a couple of years ago, the dialogue started, and now as a pursuant to that dialogue, the Bar Association of India is very much involved, and we have now planned to set up an international arbitration center here with special support and with special legislation also that is in the offing. With that, both mediation and international arbitration could become centered in places which is outside the traditional forms of international commercial arbitration. That is going to have great deal of benefit from the point of cost, from the point of view of convenience, and the only challenge that we have is the problem relating to enforceability of these awards. I think that is something which the Indian courts have to, still grappling with it, because arbitral awards passed in India and the territory of India is amenable to Indian courts jurisdiction, though there are recent decisions which say that even if an arbitral tribunal is physically sitting in India, but is an international tribunal and international foreign law is to be applied by them, challenge to Indian court does not lie. That seems to be the recent thinking of the Supreme Court. So I think there's enough food for thought to keep all of us alive and kicking. Do enjoy the session. We have a panel of experts who's going to, give you quite a bit of ideas. But since we are running behind schedule, I request you to bear with us if we are going a little too fast for a late afternoon session. Thank you very much. I now request co-chair Yakesh to please come and introduce each of the speakers and invite them. At the end of the session, he will also make a few remarks. Thank you all. Thank you very much.
Good evening, everyone. Mr. Naganan, Mr. Chandyok, members of the bar, delegates from various countries, ladies and gentlemen. You all heard Mr. Naganan in the last session, and in this session he also introduced himself. He's a very well-known lawyer, also a chartered accountant. He's a third-generation lawyer. He chose to be a lawyer, then to practice chartered accountancy for the best reasons known to him. He has been the president of Rotary Club of Bangalore, a trustee of Satyas Sai Baba Medical and Sai Medical Foundation. He has a deep knowledge of Hindu scriptures, authored a book called The Clan about the journey of his family. He's going to speak in detail later. I don't want to say much. Then next main speaker is Mr. Amarjit Singh Chandyok. There's hardly anyone in India who doesn't know him. Mr. Chandyok is a distinguished senior advocate of Supreme Court of India and been regularly practicing various high courts. He's been a former Additional Solicitor General of India, President of Delhi High Court Bar for more than 2 terms, accredited mediator and a trainer of international fame and repute for mediation cases, President of Insol India chapter. Now can I request Mr. Chandyok to share his views with the gallery today, please.
Thank you, Yakesh. Once we say we don't need any introduction, then I thought we should stop then. There's no need to say anything further. But you're always kind. Let me start on a different note altogether, though I thought I'll start with a different note after Mr. Naganandji has given me some hints. An agreement was executed between an Indian company, a foreign company with Government of India. The activity was to be carried out in India. It said Indian law would apply. That's the Indian law, that is the underlying contract. Then there was an arbitration clause which said the curial law would be uncitral. The arbitration shall be governed by English Arbitration Act, and the place of arbitration shall be Malaysia. So this is the real complex situation that we fall in, where we are looking at what should we do in order to first avoid when we are actually drafting our agreements, to see how we can synergize the disputes into place where we are a party to lesser disputes rather than making them this. And I remember I was a part of that case, and I think flight from London, I had to go to Malaysia. Malaysia court will say, I have no jurisdiction. London said, I have no jurisdiction. Ultimately, we came to India. So really don't know what will happen ultimately. I went out of it, so I don't know what happened. But that's what the complex situation is. The second part, Naganandji said with respect to funding. And I only want to bring home a submission to all of you for consideration. That if you see the doctors, for example, the nursing homes, if the government was to provide health, it was not possible to do so. So there's a private sector that is coming in. But that private sector is actually a businessman who is the investor into a hospital, and the doctor is only hired for a particular field or a specialty. So there's a de-link, there's a communication gap between the doctor, the patient, and the hospital. And that's where you find today violence coming with respect to the same. So we'll have to think it over again before India opens up to that funding situation with respect to arbitration. To me, countries are competing over vigorously for economic development. Market size and potential, institutions and regulatory quality and openness in trade, infrastructure quality, economic and political stability, and labor quality, as well as cost, are still paramount. So what we need to look at it, Naganandji already told us some of the institutions that are paramount with respect to arbitration, and I think Dubai has now entered the field very recently, once again, and is competing with everybody. My first would be that notwithstanding what laws are applicable to the agreements, at least these institutions must come to an understanding to have the same rules for arbitration or with respect to mediation, because the rules are different. And today, as Naganandji said, we have a domestic arbitration, which is normally ad hoc. The institutional arbitration is not really picked up. The rules are framed by every arbitral tribunal because the law provides it. So we need to first look at it, how do we interface, because that's the subject that we have looked at into international commercial dispute resolution, challenges and prospects of developing network centers of excellence. As he said, we are developing an international arbitration and mediation center. I'm sure we'll be happy to know that we already got a completion certificate. I hope and expect that we should be able to inaugurate it in the later half of post-vacations. We are running clockwise to see how we can accelerate it. And expectation is that all BRICS countries, at least to begin with, will have one fundamental common principles of law and procedure especially, so that awards with respect to these countries, even cross-border, or they want to come in enforcement, there is no difficulty in this country, at least amongst us. The Bar Association of India is working on it, and I'm sure we'll make a move towards it by the time the center is ready to be opened. The second part is, the problem is with respect to enforcement of foreign awards. So we talk of New York Convention, we talk of Geneva Convention, but today, if the law has undergone a new challenge to us, and that challenge is that today 2 Indians can enter into a contract to have an arbitration in Dubai, arbitration in London, arbitration in Singapore. So as he pointed out that this Indian Supreme Court said, with all humility at my command, that if the arbitration venue is India, notwithstanding that the foreign law is applied, I will have no jurisdiction. A prima facie seems to be incorrect. Because the place of arbitration is the first principle which court will have jurisdiction with respect to challenge to that arbitration. Enforceability is a different question. The question has also arisen today that if I am in a cross-border situation, I have assets in Sri Lanka, I have assets in Nepal, I have assets in India, where do I have enforcement? And if enforcement has been allowed at Nepal, for example, would those same principles apply when it comes to enforce under Part 3 of the Arbitration Conciliation Act? Now, these are disputes which will be ironed out as we move above. But at this moment, the greatest challenge to us is uniformity. We must have uniformity. At least core procedure. Law we can't. At least core procedure that should apply to us. Take, for example, in Singapore, if I have an arbitration award, that arbitration award goes to a committee for scrutiny, not that for changing it. So that if you are able to point out some mistake with respect to the arbitral tribunals, what it's doing, you are able to point it out. Therefore, we need to bring the uniformity within these arbitration institutions. That seems to be the first challenge in my humble view. Because if you are able to achieve this part, then notwithstanding whether I've gone to London or I've gone to Hong Kong or I'm in Dubai, I shall be able to at least iron out those difficulties. A question has today arisen and is pending consideration that supposing there is a law of domestic law of that country which prohibits those goods, could there be an award contrary to that and can be enforced in India? Because the assets are in India. The country where the work has been done prohibits it, but award has come from a tribunal. Therefore, laws on international field, especially the commercial dispute, after coming into force of Singapore Convention, though it is pertaining to mediation, I'm sure we'll be able to bring out something like similar to that, so that a convention, we have a Hague Convention in place, UNCITRAL in place, but they have not coming to our aid with respect to any of these challenges that we have. And if we need to develop, my dear friend in the last session said, India is best, India will rule. I'd beg to tell him, India is already ruling. My statistics of 2019 told me that there is no law firm in the world of some substance which did not have an Indian advocate. What could be more prevalent than that? Everyone. It is not that some of us may say कि हमने इसलिए रख लिया कोई जुगाड़ हिंदुस्तान को आता है, नहीं. We have kept those people, we have brought them there because to assist and help my friends in other parts of the world to see what is a meaningful study of that matter so far as India is concerned. We have learned this through our privileges, we have learned through our values that our forefathers gave us, we have learned through our seniors. And I want to tell this august gathering, I am holding a session with respect to how to capacity building of lawyer, where a lawyer is coming to teach us all how to read our files. Therefore, we must make that beginning. Because if we make that beginning, we will go to a destination that we are seeking with so much of competition all round, with so much of vigor with what we are working. I don't think I have any doubt that our judicial systems cannot absorb all these challenges. We have the capacity and capability to do so, but we need a one-goal vision. We need to understand what is there that we need to touch upon. I just want to, I'm not criticizing anybody here, nor do I intend to do so. But I think it's a time when the government must be advised, and my friend, if he is here still, should be able to take up that challenge with him. I in fact told the Attorney General this morning only, that if I am becoming a member of Bar Association of India, why should there be a GST on me? There is no service rendered. Therefore, please examine it. Similarly, I think in order to make an international global trend to look at on dispute resolution, especially in relation to commercial law, I think time has come when experts, Mr. Ganguly is sitting in the audience, who are experts in the field, must be looked at, must be requested to assist them for the purposes of creating a legislation. Therefore, the Parliament, the Judiciary, and the lawyers, or people who are experts in that field, must join hands in order to ensure what kind of legislation we should bring, even if you have to amend Part 3 with respect to enforceability. And I think we have gone a very large part, and my friends from other 20 countries that are here would be happy to note that in the last 7 to 8 years, we have developed arbitration's justification or law relating to arbitration. Naganand ji in fact said Supreme Court has given the maximum judgments. I wanted to add that something to it, that out of, if this country had 2,000 cases on arbitration, 1,500 were decided by Delhi High Court. Therefore, law is developing. Unless there is patent illegality, the court is not wanting to interfere. These standards need to be brought into our international connections, into institutions that are of excellence, to ensure that commercial disputes are resolved in a time-bound manner. We have brought Commercial Courts Act 2015. We have amended that act twice thereafter. We have now brought mediation as a first part, as a mediation is compulsory. But all these are steps toward the same direction, that a commercial dispute must end immediately, as soon as possible, and should not linger on in courts. Thank you very much.
Friends, before I call upon the next speaker, I must add, Mr. Chandok referred to about 1,500 decisions pronounced by the Delhi High Court. Mr. Chandok has a credit of about 200 to 300 of those judgments. Our next speaker is Mr. Carlo Dio, who is Vice President of UIA. one of the biggest association of lawyers. He's an international business lawyer with a dual nationality, British and Italian, and with over 30 years of experience in a variety of sub-areas, including ongoing business, legal consultancy and advice, company and commercial law, contract law, compliance, international business and trade law, real estate, construction law, and dispute resolution services. He was enrolled with the Florence Bar of Italy since 1983 and had also been admitted to represent clients from before the Italian Supreme Court. He is a member of supervisory boards under legislative decrees 231 of 2001 and accredited mediator. Mr. Carlos is presently a director of publications though he was a former director, but for a few years, he's the director of education, legal projects, and much more. Now I'll call upon Mr. Carlos who will give his address, please.
Put this on here. Good afternoon. Thank you, Mr. Chairman, Mr. Co-Chairman, ladies and gentlemen. Thank you for inviting me here. Let me give you a slightly different perspective since we are dealing here with international commercial dispute resolution. And please, if the 10 minutes expire, do ring the bell. Thank you. The UIA, the International Association of Lawyers, I have the privilege of acting as the Vice President, is a strong promoter of international alternative dispute resolution. And you've heard a lot here about international arbitration. A slightly different perspective, but is strictly connected with international arbitration, is mediation. And the UIA holds an annual event, an annual forum on international arbitration, which is permanently in the city of Bilbao in Spain every month of May. But it also handles what we call an international mediation centers forum, where all representatives from all the world, from mediation centers, meet. And when they meet, they try to put together the solution to the procedural issues which is not resolved in international arbitration, but might be more resolved in mediation, which is less proceduralized, which is the concept itself of mediation, which is based on understanding and on understanding one another's with the facilitation of a third-party neutral mediator, and based on the mediator being capable of extracting interests of the parties, facilitating reaching an agreement. Now, we are here in an interconnection between the rule of law and alternative dispute resolution. And if I take the definition of the rule of law as suggested by the report of the United Nations Secretary General on the rule of law and transitional justice of the year 2004, which we as the UIA have adopted in Kuala Lumpur, Malaysia in 2017 as the definition of the rule of law we would like to follow, is a governance in which all persons, institutions and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, and looking through this and looking to what is consistent and relevant for both mediation and arbitration, or for either of the two, independently adjudicated. Now, independent, of course, is the mediator is not an adjudicator, is a facilitator, but the independence of the arbitrator and the independence of a mediator is critical, as well as consistency with international human rights norms and standards, which is relevant for both mediation and arbitration. It requires adherence to the principles of accountability to the law, fairness. Fairness is extremely important in both scenarios. separation of powers, avoidance of arbitrariness, and procedural and legal transparency. All these principles which relate to the rule of law are very important and central for finding them in both mediation and in arbitration. Now, the problem with international mediation, which results when it is successful, and if mediators are good, it will succeed into an agreement, a settlement agreement, is the issue of recognition and enforceability, with the difference that the 1958 New York Convention is sort of a well-known and vastly adhered by international convention. There's so many countries, in excess of 100, who have signed the convention, whilst with mediation, we are referring to, again, it's the United Nations Convention on International Settlement Agreements resulting from mediation. It's known as the 2018 Singapore Mediation Convention. Now, the European Union has not even signed this convention. India has. So India, in effect, we are waiting for ratification, but the European Union hasn't even signed it, so it's very bad performance by the countries of Europe. The issue here is securing recognition and enforcement of a settlement agreement reached as a result of a mediation process. Now, it is true that typically parties to a mediation agreement would voluntarily abide by the terms of the agreement they've reached. Not necessarily, but generally yes. Because there's no party that has won, it's a win-win solution, and that is why both parties would be happy to comply. This doesn't mean that there is non-compliance. There is non-compliance, and that's why the treaty is there and should be signed. Now, the problem about enforcing a settlement agreement, and there I say it's connected with arbitration, is that if you have a party which is resident in a member state of the European Union, it's necessary to have the settlement incorporated in an arbitration award, a consent award, or depending on the jurisdiction, have it converted or incorporated into a court judgment. And I would imagine it's probably similar the same way, the other way around, with an Indian party. So the issue is that significant challenges remain for enforcement by an Indian party of a mediated settlement agreement if it has to be enforced in a foreign country, insofar as we do not yet have ratification of the Singapore Mediation Settlement Convention. So since this is a very illustrious international forum, I think one of the messages we could give, Mr. Chairman and Mr. Co-Chairman, could be that we could try to have our voice heard as lawyers, the need for our governments, whether India or the European Union governments, to sign and enforce the settlement convention so that we have an additional instrument. Because this is the future. I see a great future for mediation because there is less objections in principle to an arbitration. There is a situation where there is a possibility for us lawyers to play a much different role in trying to put the clients at the center. With an arbitration, we are still pleading. It's very similar to the jurisdiction. With a mediation, which can be a step, if mediation fails, we still have the jurisdiction, we still have the international arbitration. But with open-minded lawyers, such as we should be here on an international scenario, if we were to encourage our clients to first try an international mediation, and if that is successful, we would have happy clients, and they would be very grateful to their lawyers for having found a way for reconnecting the communication which has been lost between the parties, and then going beyond and doing more business. I'm going to stop. I hope it's before the 10 minutes. Thank you for your patience. Thank you.
Friends, our last speaker today is Mr. Yunus Nasibo. He's an advocate and member of the Bar Association of the Republic of Azerbaijan. He holds an LLM degree from UK and a PhD degree. He's a partner with the law firm Kamadar Nasibo and Partners. He specializes in commercial law, contract law, administrative law, and banking law, in addition to working in the field of oil and gas. I'll request Mr. Yunus to give his address.
Good afternoon, everyone. I'd like to thank you for your invitation on behalf of myself and on behalf of my colleagues and our delegate from Azerbaijan. Previous speakers mentioned about the domestic arbitration and the international arbitration, and I will address mainly the regulation and practice of commercial dispute resolution and arbitration in particular in Azerbaijan. While there is the significant uniformity in international arbitration legislation around the world, there are some differences in how the national arbitration law and the courts implement them and apply the New York Convention. I believe the prevalent approach in Azerbaijan is to choose litigation over the alternative dispute resolution. As a matter of practice, commercial practice, do not refer disputes to domestic arbitration in their contracts. In Azerbaijan, the practice of alternative dispute resolution is relatively new, and it is it's in the process of development. The Bar Association of the Azerbaijan Republic is taking the leading role in this process. It regularly organizes the conferences, roundtables, seminars, and the member of the bars, the advocates, are taking active role in various international organizations, giving lectures in universities about the commercial dispute resolution and arbitration in particular. Within the Bar Association, we also have a business law committee that deals with business and commercial law. It greatly contributes for the development of this area. Azerbaijani law recognizes the right of parties to refer dispute to arbitration in another country or to a tribunal in Azerbaijan, which will apply only foreign law. The national procedural law of Azerbaijan Republic on international arbitration includes the Civil Procedural Code and the Law on International Arbitration dated 1999. In early 2000, Azerbaijan Republic ratified and acceded to the 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. And Azerbaijan also is a party to a Washington Convention on the settlement of investment disputes between states. However, even prior to that, the Republic of Azerbaijan adopted many conventions and became a member of different international organizations. For example, International Center for Settlement of Investment Disputes of 1965 and the European Convention on International Commercial Arbitration of 1961. The law on international arbitration in Azerbaijan has been enacted on basis of UNCITRAL model law on international commercial arbitration, and I'm sure this is the same case in many countries. The main object of this law is to encourage settlement of disputes amicably via the arbitration. When talking about the peculiarities of international arbitration, there is almost always an issue with the country's own legislation. And in Azerbaijan, it is certainly worth noting that there is an important lexicological inaccuracy within the laws was enacted because the arbitration was new at that area. And of course, this may cause a confusion. In my opinion, the legislation in all countries, including Azerbaijan, should be unified and consistent with each other in order to get the desired outcome, especially in practice of recognition and enforcement proceedings. Nowadays, it is difficult to imagine the resolution of disputes, international and domestic commercial relations without the arbitration and mediation processes. In 2019, the law on mediation was adopted in Azerbaijan, and this law regulates the public relations in the sphere of establishment of mediation as one of the alternative dispute resolution methods. The adoption of the law on mediation is an integral part of the ongoing judicial and legal reforms in Azerbaijan. According to the law, mediation is a process defined by the law on mediation, which regulates settlement of disputes arising between the parties through mutual consent and will be applied to the civil and economic disputes. Currently, it is compulsory for 3 areas in Azerbaijan, and those areas are labor, family-related, and commercial disputes. In a way, it's good that it's a compulsory, in my opinion, because there are real cases that can be solved in mediation without taking the traditional route of litigation. It can save time, money for parties, and minimize the caseload of the courts. In my opinion, also the mediation plays an important role, especially in commercial disputes. As I mentioned, there are ongoing judicial and legal reforms in Azerbaijan. We are taking part in many projects related to dispute resolution, and members of the Azerbaijan Bar Associations are active members of the ICC committees, the London Court of International Arbitration, as well as the ICCA, the International Commercial Court of Arbitration, and they also act as international arbitrators in the relevant field. Students are also in the universities are taking part in international moot competitions, and they are all making contributions for development of this area. There are also many projects that were carried out by various international organizations. For instance, in 2020-21, the European Commission, together with the Minister of Justice of Azerbaijan, had a project called the Support Further Development of Alternative Dispute Resolution Services and Specialized Courts in Azerbaijan. During this time, the 10 to 15 members of the Bar Association, the advocates, were elected and enrolled onto initial course on arbitration. This all shows that as a country, we are very interested in developing the commercial dispute resolution and the ADR. The end of October 2002, the New York Convention roadshow was held in Baku, Azerbaijan, and during the event, the new Azerbaijan translation of the ICCA Judge's Guide to the Interpretation of the 1958 New York Convention was officially presented. The event drew nearly 100 in-person attendees, including the judges, attorneys, state officials, and professors. The event was co-hosted by the Azerbaijan Bar Association, the UN High Commissioner for Human Rights, the Baku office, and the Small and Medium Business Development Agency of the Republic of Azerbaijan. Currently, there is a new law on arbitration is in the process of drafting, and we hope it will be accepted in the near future. Also, there are new law on investment, which is very good for the investors. This will protect the rights of investors and give them the peace of mind. At the same time, I'd like to mention that many books during this time were published in relation to commercial dispute resolution and arbitration in particular. This all helps to educate the young lawyers and students on this subject. And again, the Bar Association is playing an important role in all these projects, and recently, in October of last year, as I mentioned, the New York Convention of Roadshow was held in Baku. The new arbitration, in addition to all this, what I said, the new arbitration center in Alat Economic Zone, basically, this is the new authority, the new institution for us as well, and it will basically deal with the disputes between the residents of the economic zone. It all shows that there is a big development in this field. And Azerbaijan, being an oil exporter country, Azerbaijan also have joined to the Energy Treaty Charter. The treaty provides a multilateral framework for energy cooperation that's unique under the international law. And the main purpose of the Energy Treaty Charter is to strengthen legal norms in the energy sector by establishing uniform rules to achieve the compliance with these rules by all participating governments, while minimizing the risk associated with investment and trade in the energy sector. So, as you can see, There are many ongoing projects and legal reforms in Azerbaijan. However, there are still challenges in this area which needs to be overcome, especially in the area of enforcement. And in conclusion, as a country, as I said again, I want to repeat myself, we are very interested to overcome those challenges and also interested in further development of the commercial dispute resolution. I believe the outcome of this convention will be very useful, and we as advocates, lawyers, and practitioners, even students, can benefit from this as a whole. Thank you very much.
Now I request Chair of this session, Mr. S. Naganan, to give his presentation.
Thanks largely to the three excellent presenters today. We are exactly on time. And we made up some lost time also. Thank you very much for that. One speaker was supposed to be there, but there was some technical issue, and therefore we are not able to present his talk. Mr. Chandiok, in his usual clarity, presented to us some problems relating to the drafting of the agreement, and then he spoke about various arbitral institutions and also the enforcement of foreign awards. And mediation is his favorite subject, and therefore he did touch about mediation. I'm very glad about that. And about capacity building. And there are some teething problems relating to GST and arbitrations, the fee, etc. That's something which has to be taken up with the government, which I'm sure the present government is very responsive and they will do it. Talking about mediation, I remembered a story which a few days ago, one of the judges who was elevated to the Supreme Court made a mention that when he was in a high court before coming here, he insisted on a party before him to settle the matter by mediation. And the mediation went on for some time, and afterwards one day, this junior lawyer who was appearing for another parties came to see him in his chambers and said, "Sir, you asked us to mediate, please don't insist. This a few cases that I have. This case I'm going to lose. I won't get any fee in this case if it is settled. Therefore, please don't be so harsh on us, we are young lawyers." So then the judge told him, don't worry, there are other things that will happen. And of course he was very pleasant to him. Finally the case did get settled and the matter got over. About 2 months later, the same lawyer came to meet him again. Told him, "Sir, I want to thank you." So he said, "What, last time you came here, you had all complaint about me. Now you are coming to thank me." He said, "No, many people saw how we handled that mediation, and all of them are now coming back to me. Because of that mediation, I've got at least 5 more cases where they want me to mediate." So this is a practical example of how mediation, the role is on the lawyers to convince the clients that this is a method which is a win-win situation. So I think Mr. Carlo also mentioned about the importance of mediation and how by various institutional mediations it can be done. But of course he has raised a number of issues relating to enforcement of mediation awards. Now in India, if it's a mediation under the Indian law, then we have the system of a Lok Adalat. Normally what happens normally is a Lok Adalat is like I would say it's a quasi court. Okay, so any dispute can go to the Lok Adalat, where a sitting judge and a lawyer or some other paralegal person is there. They try to reach a solution, and if a solution is reached, they will record the settlement, and under a Legal Services Act, that settlement as recorded will go to the court and get ratified like an award of the court. So the thing is, it becomes completely enforceable. So I think we need to look at some kind of a mechanism like that in the international field, is the point which Mr. Carlo made, and I think that's very good. The most important takeaway for me is for us in this convention to pass a resolution to request all the European countries who have not ratified the convention, Singapore Convention on mediation, to ratify it, because that's going to bring about a new world order. Thank you for that. And Mr. Yunus from Azerbaijan, I must say that Azerbaijan is likely to become a member of Law Asia. For that, I think we need to give them a good hand. We are in the process of discussion with them. And in the period when Mr. Sham Diwan is going to be the president, we are going to be blessed with one more new member of Law Asia, which means Law Asia is growing, and that's good, and therefore we need to thank Eunice and his team who are here. He did mention to us about the procedures that they have, the laws that they have, and I think it's an excellent beginning that they have made, and I'm sure as they go along, with the cooperation of the bar, I think, see, the bar has a very important role in ADR. If it does, go along with the parties, then there's a sense of confidence that ADR is working and people will get justice. I think for that, we must compliment the Azerbaijan bar for doing that. And thank you for coming all the way here and being with us. With these words, I think we'll bring this session to an end. But before I do that, I would request Yakesh, if you would like to add anything, to say a few words. With that, we'll conclude. I think we're going to be just 2 minutes behind time. Thank you.
Just to add what my other co-speakers have said, whether we go for arbitration, mediation, conciliation, or private judging or neutral evaluation, there are different skills which need to train, whether the mediators or arbitrators. There's a need to set up centers of excellence, and for that we need to have high quality training in arbitration and dispute resolution process with special focus on emerging technologies. We need to develop association between academic and the legal profession to conduct research and development. We need to upgrade the technical quality, capacity, information, and other institutional setup for have a center of excellence. We need to have a common rules. We need to have a discussion on strengthening the existing infrastructure in various countries. There are certain problems. When we talk of setting up a center of excellence, there are certain people who create certain hurdles. What are they? It's a mindset first. We need to change that. What are the challenge and obstacle we have is first compliancy. This comes from, if it is not broken, don't try it, fix it. Organization taking such an approach may be struggling with the fear of unknown, which takes hard work and encourage to do that. Then complexity. Some individual may say they don't have the time, expertise, or even experience to understand and implement it. We need to overcome this. But with Center of Excellence, it is believed to be complex and requires experts, when in fact all it needs is common organizational senses. We need a common experts who can really guide us well. Then conservation. Certain organizations and individuals take their own approach that this should not happen, but it's time we need to overcome this. Some of the obstacles and challenges are like funding, infrastructure, talent acquisition, cultural differences, political instability, sustainability, knowledge transfer. But I think with efforts, we can all overcome this. With this, I want to thank all of you for giving us time, for hearing us, and it's time for the next session. Thank you, sir.
Thank you. We have one more session after this, and there's a tea break. No break. So no tea break, as I've been informed. So last session. And then we have our cultural program and dinner.
Strictly for the panel.
Last session, working session for today. And let me thank the chair and co-chair of the previous session for managing the time very efficiently. You know, like in budget or any, fiscal expenditure, one of the biggest achievement which is considered is to cover the deficit. And here, we were lagging behind in time, and the previous panelists were able to cover the deficit, so congratulations to them. And we hope to maintain it, because we don't want to keep you away from a nice cultural performance which will take place once we vacate this stage right here. So friends, this is in a way a continuation of session 3. It relates to commercial dispute resolution and how the philosophy of the New Development Bank and BRICS can be a good model to develop a network of centers of excellence for the emerging markets and developing economies. And here, since once we finalized the program, I got a couple of concept papers from BRICS. I will like to invite Mr. Alexei Klishin also to come on the panel. Mr. Klishin is around. If he is outside, can you request him? Yes. So when we talk about New Development Bank is a multilateral development institution or lending institution which was promoted by the BRICS countries: Brazil, Russia, India, China, and South Africa. It has not only taken shape, it has come up with its own unique agenda, which relates to sustainable development. And one most significant development is by 2025, the lending portfolio of New Development Bank is going to exceed 25 billion USD in sustainable development projects. And the lending is not limited to BRICS countries, but is spread around in what is called the emerging markets and developing economies. Now, we all know that the very robust and popular dispute resolution institutions, they have come, and their emergence can be attributed to the multilateral development institutions like World Bank and IMF, because World Bank, to ensure that contracts are honored and are enforced, gave development assistance to develop judiciaries in the developing world. And at the same time, ICC in Paris, in London, World Bank encouraged that the disputes which come from the implementation of these development projects, they are assigned to these institutions, and in a big way, these multilateral institutions were responsible for bringing commercial dispute resolution, or ADR, into being. So once there is a new development bank which builds up on the model of a multilateral lending institution, development institution, but with a difference that it has a focus on emerging markets and developing economies. And the most significant difference is that whatever lending, whatever programs are there, are not policy prescriptive. Like we hear, the IMF has to give a bailout package, and these are the conditions which are to be fulfilled before a struggling economy can avail the bailout package. So there are hard terms, there are negotiations and all. So whenever those projects are there, domestic policies are to be changed, altered, so that the lender feels more secure, lenders feel that by this device they are developing markets further. But New Development Bank has an approach to work with the system which is in existence in the donor country. How to work best with them, how to understand with them, not to be policy perspective, but to be collaborators for development. And that is what we want to bring into the dispute resolution sphere also. Because with a lending portfolio of 25 billion USD, and of course, when such projects are going to be implemented, there are going to be disputes. So where those disputes should go, and whether we can utilize this platform within BRICS to expand the whole, what I call, universe of commercial dispute resolution, expand it and use it also somehow to develop capacities, to develop new centers. Because when the philosophy is to work with the existing systems, how local professions, how local capacities, local laws and other things, we can work around them and develop our systems. So that is the spirit of this session. And I have my co-chair, Mr. Krishnendu Guptu. He is Bar at Law and our EXCO member from West Bengal. I will request him to introduce the speakers.
Okay, good evening, ladies and gentlemen. The subject, welcome to this session 4. The subject has been already placed. I'll, with the permission of this chair, straight away ask Ms. Eunice Natlai Masipa, I hope I will pronounce that correctly, to address the gathering here. I'll just say a brief few words about her. She is President of the Law Society of South Africa, and she is Director of Masipa Attorneys, based in Pretoria. She is National Projects and Campaign Coordinator of National Association of Democratic Lawyers, and an activist of social justice and human rights for all. She believes in equality and African leadership. Welcome to you.
I'm trying to bring this down to my level. Okay, thank you. Good evening, everybody. Thank you so much, co-chair and chair, for the lovely introduction. It's our first time in India, and you know, everybody has been very hospitable. You've got very friendly people here, lovely food. We are having a great time. Without wasting any further time, it's been a long day, we are tired, we have been bombarded with a lot of information that we need to reflect on, so I'm going to keep this very short and get straight to the point. Generally, the legal profession around the world is ambiguous on the role of arbitration and the role of the courts, requiring equitable remedies to be left to the courts. The following is the detail of the conundrum that I just mentioned. Parties to an arbitration agreement where the dispute raises a constitutional matter regarding just and equitable remedies may be well advised to challenge the arbitrator's jurisdiction and litigate rather than arbitrate. This is a challenge that BRICS must resolve, and I've been very fortunate to have a view or a sight of the Russian paper, and the proposal that was made in the Russian paper gives us a good basis and a way forward that we can build on. In the ideal world, the following is the proposed solution that has been used in many jurisdictions that can be adapted to achieve the BRICS plus arbitration mandate. Arbiters are generally amiable compositors, but still require that arbiters use the parties' contract as a starting point. The legal framework they use or they understood, and at least some aspects of the law of the place of the arbitration where any award may be enforced as a guide. In some jurisdictions, this is good conscience. The basis of good conscience is informed by the situation where constructive trust has been recognized between the business parties. This is a basis that the parties entered into a contract or an agreement. Recognizing constructive trust as a basis of equitable justice between the parties maintains the integrity of the parties' trust-like relationship. The absence of constructive trust would have an unfair or unjust effect on the defendant or third parties, matters which equity has always been taken into account. Equitable remedies are flexible. The award is based on what is just and the circumstances of the case. Considering the various circumstances in which a constructive trust may be imposed must be general in nature. The legal profession also in many countries is fragmented, and it is essential to have a unifying force to protect the country's best interest and its society. This fits in with the critical objectives of BRICS, supported by the BRICS Legal Forum. We must also consider other initiatives and bring them into the BRICS Legal Forum, or at the very least, be informed. Each country has to commit to its international obligations, and in Africa, national interests have been slowing down the implementation of the African Free Trade Area. Unfortunately enough, South Africa has legislation that protects the foreign investment used to talk to and inform the BRICS model, which is the Protection of Investment Act 22 of 2015. Now, with that being said, the objective is defined as providing for the protection of investors and their investments, achieving a balance of rights and obligations that apply to all investors, and for other matters, two broader objectives of the Act. Now, in conclusion with my talk today, South Africa will be hosting the BRICS Legal Forum this year, and the proposed date is closer to the week ending the 1st or 2nd week of December this year. Date is still to be confirmed, and I encourage all of you to attend and take this as a formal invitation to all the countries that are here today. Thank you so much, Chair and Co-Chair.
Next, I'll be calling upon Mr. Alexei Klishin, who had spoken in the first working session, and we are already familiar with his lovely presentation. So, Mr. Klishin, please.
There are glasses here. No? Not yours, okay. Just in case. Okay, thank you very much. I will be brief. I will tell about the two concepts of arbitration institution, which Mr. Prashant Kumar mentioned, two concepts which exist in Russia. And this can be interesting and can be useful. We can use, because this procedure is quite advanced in Russia and is supported by the government and by some important institutions in the country. The first concept is the concept of the investment arbitration court. For some reason, I don't know the story, but it was brought, the project, the draft was brought by the university, St. Petersburg University, suggested to our Ministry of Justice, and we now have this as a draft. The major idea is to propose on the level of the governments to propose the adoption of the respective convention to the countries, let's say BRICS plus, meaning the members, the participants of BRICS and the countries interested in this procedure. So I repeat that this refers to the investment procedure, which is As you know, the specific procedure, specific regulation, each country has its regulation of the protection of investment, so the disputes arise from this regulation, and referring the investment process can be brought to this institution as it is proposed, but it requires a convention, and the conventional regulation, which is quite complicated, and the whole process has initiated several years ago, about 3 years ago, but still is a project, is a draft, and there is another project supported by the Association of Lawyers of Russia and some other important institutions. It concerns the commercial arbitration mechanism. It's not called court. It's also referred to BRICS plus procedure, because I'm the head of the Russian delegation on all legal forums of BRICS, so this is why I'm talking about this matter. So this another proposal is not connected directly with the state. The proposal is to set up arbitration institutions in each country, and then make a network with respective regulation, unified regulation, unified terminology, unified procedure rules, because what is important in this matter is, well, there are certain important questions. First is financing, second is arbitrators, third is the enforcement. All these matters, the experts who propose this second mechanism tried to resolve. That's why Mr. Kumar mentioned the bank, because it's important. If there is a support of a financial institution of this level, then many problems, many questions can be resolved, evidently. So to finish, the solution which we see is the merger of these two concepts and the creation of mechanisms of the resolution, dispute resolutions, which would foresee both procedures, both a procedure for investment disputes and for commercial disputes, and I hope that starting with this year, because we renew our legal forum, BRICS legal forum meetings, annual meetings. Hopefully it's going to be in South Africa this year. I think that we will push, we will move ahead with this, resolving this task of creating a new mechanism of dispute resolution based on BRICS, BRICS Plus, this movement. Okay, that's it. Thank you very much. Yeah.
May I next request Mr. Shiraz Omar to address the gathering. A few words about him. He specializes on complex, high-value commercial litigation and international arbitration. He is in the board of directors of Singapore International Arbitration Center and member of board executive committee. He also sits on the working group of Professional Conduct Committee chaired by Chief Justice of Singapore. Mr. Omar.
Thank you. Good evening. Let me begin first by thanking the Bar Association of India for the kind invitation to be here and to speak, and to congratulate the President and everyone at BAI for having put together such a wonderful event. Speaking personally, it's a pleasure to be back in India and in New Delhi in particular for the first time in a long while. I'm very conscious that my fellow panelists and I stand between you and this evening's cultural program and more importantly, dinner. That's always an awkward position to be, and I thank all of you for having stayed and for this late session. So I promise to be brief. We've been asked to discuss whether the philosophy underlying the new Development Bank and BRICS Plus can serve as a good model for developing centers of excellence for emerging markets and developing economies. That is a very broad canvas which comprises many elements, and so let me try and unpack them. And in doing so, I'm going to take a very macro, big picture view of the topic. And first, when we speak of emerging markets and developing economies, we're really talking about groups of countries at very different stages of development. Emerging market economies generally have rapid growth, high productivity levels, a growing middle class. But when we talk about developing economies, generally they're the lower end of the scale. Low per capita income, high levels of poverty, poor infrastructure, lower rates of capital formation. In other words, developing economies sit behind emerging markets in the spectrum of development. Next, what is this philosophy of the NDB and BRICS Plus that we talk about? The rationale of the NDB is to mobilize resources for infrastructure and sustainable development projects in emerging markets and developing countries. It does so by leveraging capital for development purposes to accelerate economic growth, as well as to achieve environmental and social sustainability to improve the lives of people in member countries. During a media interview earlier this week, the incoming head of the NDB, the former Brazilian President Dilma Rousseff, emphasized that NDB was different from other traditional financial institutions, and Prashant alluded to this earlier, different from other financial institutions like the IMF and the World Bank, because it focused on developing countries and aimed at eradicating poverty and furthering or facilitating industrialization. This focus on economic growth is echoed in BRICS Plus, which, according to its website at least, aims to create new and unique points of international interaction on economic development through interstate and intersectoral cooperation. How is this relevant to what we are here to discuss, which is the rule of law? From my perspective, the question we must ask is what prompted the creation of NDB and BRICS Plus in the first place? To me, the thinking that underpinned their establishment is a recognition that there cannot be a one-size-fits-all approach. Emerging markets and developing countries face different challenges from those which confront developed countries. And these differences stem from the fact that they are at significantly different stages of economic development. What the NDB and BRICS Plus seek to do is to adopt established norms and principles so that they are compatible with the needs of emerging markets and, where necessary, to create new norms and principles. And that is precisely the approach that emerging markets and developing countries should take with regards to the rule of law. Let me go back by way of illustration to something that I'm most familiar with, and that is my own country, Singapore. When we gained independence in August 1965, very few people would have bet in support of our survival. We had very little land, low levels of housing, sanitation, and education, and no natural resources. We needed foreign investment to help grow our economy so that the fruits of that growth could be plowed back into meeting housing, education, and other basic needs. Foreign investments, in turn, would only come, we realized, if there was legal certainty. Investors needed to know that their rights and investments would be protected. The establishment of the rule of law was therefore not an aspiration, but something that was of existential importance. Today, Singapore is an unlikely success. Taking just one indicator, our foreign direct investment as at 2021 was $2.5 trillion. This is in no small part due to the fact that the rule of law is entrenched in Singapore. We have a rules-based society with a written constitution that is the supreme law of the land, zero tolerance for corruption, an independent judiciary, and a fully elected parliament. But we did not, and this is where the example is relevant to what we're discussing today, we did not import principles of the rule of law rather, blindly. And let me give you two examples where established rules in other jurisdictions were adopted or adapted to meet the Singapore context. The first is freedom of speech. Now, this is enshrined in our constitution, but it is not an unfettered right. In the public sphere, there are rules to prevent speech that harms the multiracial and multi-religious fabric of our society. We learned from our history of race riots and realized that the preservation of racial and religious harmony was something that was imperative in maintaining our growth as a nation. No one wants to invest in a country where there are riots. In the private sphere, we have the common law principles of defamation, so that hard-earned reputations cannot be randomly and capriciously sullied. The second example is jury trials. And in some jurisdictions, you will know that jury trials are viewed as fundamental components of the judicial process. Singapore did away with these in 1969, shortly after our independence, because we realized that the average man in the street could not be relied upon to come to legally sound and consistent decisions. And that uncertainty would promote legal uncertainty, which would not be conducive for investment. Our approach was succinctly summarized some years ago by our Minister for Law, Mr. K. Shanmugam, who said, and I quote, "We can recognize the universality of the principles of the rule of law, but in applying these principles, in assessing whether a country adheres to these principles, we must be sensitive to its circumstances and the challenges which it faces," unquote. Ultimately, for the rule of law to become entrenched in a country, it requires the buy-in of the general population. The NDB and BRICS Plus promote an approach which places sustainable economic development at the heart of decision-making. This approach targets the upliftment of the country as a whole. And adopting the same approach with regard to the establishment of the rule of law is, in my view, surely the right way forward. Let me close by referring to something Mr. Naganan said earlier, which was the Singapore Convention for Mediation. India, like I think it's 58 countries now, was a signatory to the original convention. Every year in Singapore, we have a week which we term Singapore Convention Week, where there are lots of activities discussing arbitration, mediation, commercial courts, dispute resolutions. This year, it's in Singapore from the 28th of August to the 1st of September, and on behalf of my country, let me invite all of you to Singapore during that period. Once again, thank you for having me. I wish you all a successful conference. Thank you.
May I ask Mr. Hiru Advani next to address this gathering? He is listed in the international who's who of arbitration. He is a member of Dubai International Arbitration Center. He is presiding member in a number of domestic and international arbitrations. And he's also, incidentally, mentioned and in the Legal 500 India. Is that correct, I'm sure?
Thank you, Mr. Prashant Kumar and other members of the Bar Association for having me here tonight. I guess my talk is going to be something of a continuation of the last session and link it with Indian law as well. I'm a member of the Dubai International Court of Arbitration, DIAC, and I'm a member of the CIAC Court of Arbitration. I'm a practitioner in India and only exclusively India, although I do a lot of international arbitration. So I want to explain to you a little bit how it works and how it links up with a very, very topical current case which is being run in the Supreme Court presently before a 5-judge bench. The way the DIAC and the SIAC are structured is you have a board of directors on top first. And their role is to publicize, get more cases, make sure the SIAC, DIAC is popular all over the world. So countries from Europe, US, Russia, China, everywhere come and arbitrate in SIAC. And DIAC is doing a similar thing. They have a board of directors of very, very eminent people who go all over the world publicizing that Dubai is such a wonderful place. Why not do the arbitration there? DIAC is well regulated, etc. And underlying them, you have a court. You have a DIAC court, which is not a traditional court like we think of, like the High Court or the Supreme Court or not. It's just a number of eminent global international arbitration practitioners who form the court. And their role is simply to appoint arbitrators. If there's a conflict of interest between arbitrators, to sort those conflicts out. Or if, for example, some party is joined as an arbitration, under the rules, is it permissible, not permissible? Can you combine arbitrations? So it's more of a role of appointment of arbitrators rather than anything else. And when you look back in India compared to international arbitration, in India, it's the only country in the world probably where the courts appoint the arbitrators. Normally, all arbitrators are appointed by institutions. In Singapore, by the SIAC, in Dubai, by the DIAC, in London, by the LCIA, in Paris or rest of the globe, by the ICC. These are all institutional appointments. They appoint all the arbitrators, and no courts come into it at all. No courts come into it. They don't interfere with those decisions, etc. And if there are any conflicts of interest, and there are a lot of conflicts of interest, to sort out those conflicts of interest and to make sure we have arbitrators who are independent and not linked to any party or not linked to any law firms, etc. That's the role that the court plays, and it's called a court, but it's not really a court. You don't listen to parties, there are no disputes, there are no presentations to say this one is wrong, this one is right, I didn't get a fair hearing. You don't get a hearing. It's simply an administrative court which appoints arbitrators, unlike the courts in India, where the courts appoint the arbitrators. Now, one of the current big disputes going on is a non-signatory to an arbitration agreement, can they be a party to an arbitration or not? It's a global dispute going on. Several countries have taken the view, no, they cannot be party. Several countries have taken the view, yes, they can be a party to the arbitration. In India, after chloro control, it was common practice that non-signatory, that they were tied up with either the transaction or some way benefited from the transaction, etc., could be made parties to the arbitration. And those decisions have ruled for some time till there was a recent decision of Justice Ramana which opened up and said, I'm not sure the decisions are right. So this is all being considered by a 5-judge bench presently in the Supreme Court. And the biggest argument was that, one of us made, I made in fact, was that, look, should you be deciding this issue at all? Because if the courts are not going to play a role as an arbitrator, our Arbitration Act is amended. It plans to have institutional appointment as an arbitrator, and sooner or later that institution will come into place. It's in process, it isn't there now. We heard there are a number of institutions in India. Yes, they do exist, and they're very good and they're very fine institutions. But they don't have powers to appoint arbitrator unless the court delegates it to them. The court can take a view that instead of going to this issue, we will delegate the power to X, Y, Z. But it's not the right of the institution to appoint. That's going to change when our Arbitration Act, which has been amended, gets gazetted. It has not yet been gazetted. And then it'll go. So all these issues, whether there should be a non-signatory joined to the power as the arbitrator or not, we argued all this should be left to the arbitrators. The arbitrators will get into the facts. The courts are not a trial court when you're appointing an arbitrator. The arbitrators are trial courts. They will go into the facts, they'll come to certain conclusions, and then decide whether in a fit case a non-signatory can be a party or not be a party. All that you lay down is broad guidelines, broad principles, and leave it to the arbitrators, and not for the Supreme Court 5-judge bench decision to decide whether or not a non-signatory should be party every time, because the facts will be different in every case. We say leave this to the institution, let the institutions do their job. This is precisely what they do all over the world, except in India. So we hope there's going to be some changes here. And just one or two comments which came out from the last session. In fact, Mr. Naganan said that champer tea is prevalent in India. It is prevalent. But there's a Supreme Court judgment which says third-party funding is not illegal. So in fact, it is going on. All we are suggesting, make rules for it. Third-party funding is very wide in India. 2 or 3 third-party funders already have offices. And assuming I'm wrong for a moment and on a champer tea they're bound, what if it's international arbitration and a party comes from London or from Paris? Third-party funding is completely legal there. So they come funded, the seat happens to be in India, it's an international arbitration. So just imagine, if it's a foreign party is allowed third-party funding, if the Indian party is not allowed. I mean, is that going to be fair? Which way is an arbitrator going to look at that? He said that if a European party can have third-party funding, seat happens to be India, why can't an Indian party have the same advantages or disadvantages, whichever way you look at it? And we strongly recommend that some kind of regulation be done on third-party funding. Coming back to Dubai, Dubai and India have a free trade treaty. There's a lot of business going on. A lot of Indians sit in Dubai. A lot of companies have their offices in Dubai or subsidiaries in Dubai. Under Section 44 of the Arbitration Act, under the New York Convention, India recognizes the parties who only ratified and allow their... Now this ratification process hasn't taken place. These are small things which need to be ironed out so that the Dubai Center can work and people can have arbitrations there, awards are enforced in India in a regular manner. They've had a treaty from 1990 where arbitral awards and Dubai judgments can be enforced in India. But the small minor ratification process hasn't taken place. We heard also about the Commercial Courts Act and what a big step up it is. Of course it is. It's an enormous step to have commercial courts to have disputes decided in a reasonable amount of time. Even today, if you ask any international company, will you do an arbitration in India? The answer is going to be no. And like Mr. Nagaran said, it's a deal breaker. Why? Because the awards are going to be challenged in courts. And we know how long it's going to take in the courts in India. It's going to take 7, 8, 9 years, 10 years. We don't know by the time the dispute is resolved. So although the Commercial Courts Act is there, it's working in Delhi quite well, better than other cities. In some cities, these issues are decided by the city civil courts or the district courts. Then you go to the High Court, then you go to the Supreme Court. So to actually resolve a dispute in India can take anywhere by 10 years. You ask any international company today also, would you like to do an arbitration in India? The answer is going to be no, it's a deal breaker. So there's just a few comments that links India to the whole arbitration world and have small things, if they can be ironed out, I think we'd see a lot more disputes being decided in India, international arbitration, because we have very sophisticated courts, very pro-arbitration judgments, excellent Supreme Court judgments. We have got the platform, but it still doesn't seem to be working. It needs a little bit of tweaking to get there. Thank you very much.
Thank you, Mr. Advani. You have given your perspective from decades of experience, both in India and abroad. So even when we talk about, and we have been working on the BRICS arbitration network, we are also pushing South Africa and Brazil to be ratified, because that has not happened as yet. So as I say, there are these creases which are required to be ironed out. But what we are facing here in India, in certain ways, is also faced in South Africa and other places. That is the entrenchment of arbitration institutions of repute, how the court takes them, and how the parties, especially the foreign companies and all, are going to perceive them. Because arbitration, commercial arbitration, has to be in a neutral place with neutral panel of arbitrators, and that's how the system works today. India's most of the arbitrations go to SHIAC because not just the efficiency of it, but also because it is a norm in international commercial arbitration to look for neutrality and neutral centers or institutions to resolve disputes. So that is where the conceptualization of BRICS plus network comes in. And that conceptualization is that each center in each country, for the purpose of domestic arbitration or whatever they are doing currently, remains so. But once they affiliate to the larger BRICS network, they retain their infrastructure, they retain their financial autonomy, but they abide by the institution rules of the network and also the pool of the arbitrators. So what happens, this leads to more, the concept leads to more efficiency, because like if the dispute is relating to a project in India and all the experts, evidence and everything is based in India, even when you want to have neutrality, under this network you can have the neutrality and also save the costs and carry out arbitration, the major part of it, where all the experts, all the evidence and the knowledge of the local law is there. So this will go on to reduce the costs, bring efficiency, and the next most vital part, and that is what is concerned, we are concerned with as bar associations, capacity development for the local profession. Because unless until you get to work on the big ticket cases, big ticket disputes, there is no scope for such capacity to be developed. Then everybody is talking about the big ticket disputes. Here also we are saying that unless until you get to that level, you get that opportunity. But what falls between the cracks are the disputes relating to commercial transactions, cross-border transactions, international trade, which are in the region of $5 million or something. Now, with a $5 million trade dispute, where there are small margins, and then spend another huge amount in resolving a dispute in a neutral jurisdiction, the whole dispute resolution concept becomes unviable. Because for parties to take a call, whether for this amount to go to a neutral arbitration center or whatever has been designated in the contract, makes a business sense at all. But in developing countries and emerging markets, a dispute of $5 million is a huge amount, because that means one business will shut down because of lack of dispute resolution. Along with that, the ones who are working there getting employment, they will lose their jobs. So it's cumulatively very challenging for the emerging markets and developing economies not to have platforms which can address the disputes which are not of a very high scale to make a business sense to go to neutral centers and resolve them. So that is where we say that the BRICS network can work, bring value on this, and our friend Siraj mentioned that Dilma Rousseff is taking over as the president of New Development Bank. She was the president when we launched the BRICS Legal Forum. She was our host in Brazil, and now she takes over as New Development Bank president. As BRICS Legal Forum, we are going to approach and seek both support and funding for the New Development Bank. She is an excellent economist by training. She understands these concepts, and we'll hope that as the legal forum with the working papers and the structure in place, with the support of a multilateral institution, we can start implementing these concepts and ideas and structure institutions which can address the gap in service. As I say, that the disputes which are not presently viable to go to neutral centers because of the costs involved, and also develop capacities, bring more opportunities, and create neutrality through a network. that you remain, you are what you are, whether Bombay Arbitration Center, New Delhi Arbitration Center, but as a part of network, you attain that neutrality, you reach out, you overcome the limitation of something being New Delhi or being Bombay when you become BRICS Plus. So I think I have taken more than time, and I thank each one of the panelists who have made wonderful presentations, and also my co-chair. So with this, we close the formal working sessions of today, and within 5 to 10 minutes, this stage will be redone for a cultural performance. Please stay back for that, and then we'll have dinner. So thank you very much. Thank you very much for your patience, for your participation.